So, pronouncement of judgment item 44. So, allotment of the stall in favor of respondent number 3 set aside. Fresh NIT should be issued. Okay. Only one thing, madam, you are for Mr. Goswami.
Yes.
That contempt also can be closed down.
Contempt, okay. I'll be confirmed. Yeah.
Huh?
I'll be confirmed.
Where is he? Where is he?
He's in another column. I'll be
List it
confirmed.
tomorrow. We'll leave the contempt tomorrow.
And after vacation, maybe.
Why? Why should you see this contempt should then it says it'll be a problem for this respondents also.
Yes.
I'll let him come today, Mr. Goswami at 2 o'clock.
2 o'clock.
Ah,
Okay.
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 This is the way of disposal.
Or last weekend.
Ah, ah. Yes, that lady, petition. Whenever Mr. Goswami is available, tell him to come.
Okay.
Because he's saying that might not be possible to upload the order in the absence of the contempt case, because it's linked.
My lord, I beg to mention item number 46 of supplementary list on behalf of Mr. N. Saikia, my lord. She is not well, my lord. It may come up after vacation.
Okay, right. On the prayer made on behalf of Miss Encyclia, this is the matter after vacation.
Lordship, I beg to mention two writ petitions, Lordship. For both the items, Lordship, IA has been filed for some typographical mistakes, so may come up on 7th January. Lordship.
May I plead your lordship?
Typographical mistake,
Lordship,
that can be corrected anytime.
this is by the code number 5. Lordship.
Oh,
May I plead your lordship? With the consent of the petitioner, I beg to mention item number 43. In this matter, lordship, today I have filed Ukalatnama for respond number 1 to 5. I need 4 weeks time to file our objection, lordship. 43. 43.
you want to file what?
I have today I have filed
You're for whom?
for respondent number 1, 2, 3, and 4, 5.
So you want to file affidavit opposition?
Opposition.
How much time?
4 weeks time.
Miss, your name?
R. Kakoti.
R. Kakoti, learn counsel for the respondent numbers
1 to 5.
1 to 5 is granted 3 weeks time to file affidavit opposition. This is the matter of 3 weeks.
Lordship, can it be on the 7th of January?
7th, why 7th? Okay, this is the matter of 7th.
Lordship, a similar pair in item number 24. In this matter, I am appearing for the petitioner. Lordship, I need 2 weeks time to bring instruction from my client, lordship. Item number 24.
This is for fishery,
Yes, lordship.
then,
Lordship, I have to bring instruction from my client, lordship, because the
yes.
I'm for the petitioner.
Who is for the, she's also for the petitioner.
24 Kalpana. No, I'm mentioning 24.
Sorry.
Have you spoken to the fishery
Yes,
council?
yes, lordship.
Miss R. Kartaki, learned counsel for the petitioner, prays for adjournment to obtain instructions from her client. So she submits that she has taken the consent of the petitioner for the counsel for the fishery department. Accordingly, leave this matter
After vacation.
after the case.
May please, Your Lordship. No, I beg to mention item number 20 with that. I am appearing for,
Acha, she has taken the consent of the council for the other side.
beg your pardon?
No, yes, item,
Item number 20 with that.
yes.
I am appearing for the respondent number 8 with due consent from the other side, Milord petitioner. Let it be taken up after vacation. In the meantime, Milord,
You'll
after
file affidavit.
file affidavit, Milord.
My lord, I appear for the petitioner. Can I have a fixed date after Bihu vacation?
After due vacation.
Mr. S. Kataki,
Yes, Milord.
learned counsel for the respondent number 8 is granted.
For
for which time to file affidavit in a position. List the matter. Obliged.
May I please your lordship, my lord, I pray for a listing of a motion matter on Wednesday, my lord. It is regarding running of a cattle market, my lord. Wednesday.
Why not tomorrow? Why not tomorrow?
Tomorrow, sir, your
Tomorrow, tomorrow.
Obliged.
Similar prayer for listing of the matter tomorrow, Lordship.
New matter
New matter, Lordship.
tomorrow.
Obliged.
My lord, just now I mentioned one matter on behalf of N. Saikia, my lord. And this matter may be listed on Wednesday, my lord. This is for motion, my lord.
What is the hurry? She has not filed an affidavit also.
My lord, I have mentioned.
She was supposed to file
after
additional
vacation.
affidavit, madam.
My lord, just now I mentioned, my lord,
I know.
after
You
vacation.
see, the problem is, as per the last court order, she was to file an additional affidavit. She has not filed it. There's no point listing it day after tomorrow.
Then on Friday, my lord, before vacation, my lord.
No hurry.
Because I am mentioning on her behalf, my lord, so
We have already passed the order, signed everything. Yes,
just now I have mentioned.
we are very fast.
Friday, my lord. Because this is not my case, my lord, I am on me mentioning on her behalf, so
Tomorrow. Okay, that Miss Nsaikia's matter, no? Item
46.
46, list the matter on the prayer of Miss Nsaikia, list the matter tomorrow. On the prayer made on behalf of Miss Nsaikia, list the matter tomorrow.
May I please your lordship? Lordship, I beg to mention item number 42, lordship.
42, yes.
The standing counsel, Mr. P. Sharma for fishery, he is out of station. lordship. Concern is taken.
Taken?
Yes, lordship.
Okay, right. On the prayer for adjournment made on behalf of Mr. P. Sharma, Learned Counsel for the Fishery Department, and as there is no objection from Mr. Your name is not here, Mr. Murray. What is his name?
My lord, my name is A. Nardar.
Okay, Mr. A. Nazari, Learned Counsel for the petitioner. List the matter when?
After vacation.
After vacation.
Obliged.
Obliged, lordship.
May please your lordship. I beg to mention item number 22. On the construction, on the instruction of my nine my lord petitioners, I pay for withdrawal of this matter, my lord.
It is become infructuous basically. Yeah? The term is ended long time back. Then? Okay, right. Mr.
M.A. Hussain.
M.A.I. Hussain, Learned Counsel for the petitioner, submits that he has instructions from his client to withdraw the contempt petition. Accordingly, the contempt petition stands closed as withdrawn.
Lordship, I beg to mention for listing,
New, old,
old case.
after vacation.
Lordship, this week,
Why?
some urgency is there.
No, what is the urgency, you tell me?
Lordship, matter relates to pertaining to grant of IMFL on license to petitioner, and license fee has been paid till January. On January, the license fee will expire. Lordship.
When, which January? January 1st, January 2nd, January 31st, what?
30 January.
13th, 30th January, 31st January, you mean? Yeah, 31 days, 30 January, enough time. And list the matter, give it the first week.
10. Please, your lordship. On behalf of Mr. B. Goga, I beg to mention item number 26, your lordship. Lordship, the matter may be listed after vacations, your lordship.
Yeah, for the petitioner,
Your lordship.
on behalf of Mr.
B. Gogoi.
B. Gogoi. Give me. Adjournment prayer has been made on behalf of Mr. B. Gogoi. Next para. As per the office note dated 2/3/20, comma. Unserved notice has been returned in respect of respondent number 1 with postal remark, inverted commas, no such person at address to sub return to sender. AD card for respondent number 2 has however been returned. There is no return of AD card or unserved notice in respect of respondents number 3 and that was 4 years back, madam. Is he really interested in pursuing this matter?
Your lordship, I think there's a repetition going simultaneously going on in the same. That has not been disposed, your lordship.
Writ petition is going on. This is a contempt.
It's still on, your lordship, on 19, your lordship.
List this matter on your first week. On which date the petitioner's counsel shall inform this court as to whether he is pressing the present contempt petition or not. Huh?
May it please your lordship, I beg to mention item number 10 and 11, lordship. Lordship, both the matter has become infructuous, lordship.
10 and 11. Okay. Yes. Okay, right, Miss
S. Baisha, on behalf of Mr. S.P. Das.
S. Baishya, on behalf of Mr. S.P. Das, learned counsel for the petitioner submits that the matter has become infructuous. Accordingly, the writ petitions are dismissed as infructuous. The IA is also dismissed accordingly.
May I please your lordship? On behalf of Mr. B.K. Das, I beg to mention item number 13.
13.
Yes, sir. I have taken consent of the respondent, Mr. Learned K.B. Pathak. The matter may be fixed after vacation.
On the prayer for adjournment made by Mr. B, on behalf of Mr. B.K. Das, B.K. Das, learned counsel for the petitioner. List the matter after the vacation.
Item 45.
May it please your lordship. My lord, the writ petition is on a very narrow campus, very, very narrow campus. While I conceive that the respondent authorities being the authorities who have invited the tenders, they can have clauses to suit their conditions. And I cannot have a hard warning to say that, no, this is wrong. Provided it does not appear to my lord
Appeal to?
appear to my lord that it would have ramifications apparently unseen. I'll try to persuade my lord on that, on those lines. There's an experience criteria required by the respondent Oil India Corporation, which is correct in every way. They require a particular number of years of experience, so they require a particular number of experience. Now, all through these years, they had a manner and method in which this experience could be gained. Those were twofold. Firstly, I could
Problem this throat. Continue.
there were two ways in which I could gather the experience. Firstly, I could ply the bowsers or the oil tankers and thereby gain experience officially. And otherly, if I did not have the adequate numbers of bowsers or tankers, I could attach mine, which I own, with the bidder,
Hmm.
and I could still gain experience. This is the prevalent norm of
But
gaining
but
experience.
won't the bidder need to have some
Bidder
qualification,
requires
eligible?
everything. That requires everything. No. Experience on the count of number of years I've worked. Of course, it goes without saying I have to meet the financial and all other criteria. But on the experience ground, if I do not meet, I'm out. So therefore, they had a way of how experience was to be gained. Now, this facilitated the new entrance in the game, if I may say so. Because if I'm a new player
and Mr. X is not a new player. I can gain experience by attaching my Bowsers therein. So the next tender and the bid onwards, I grow and the new guy comes in. That's how local people were being protected. But suddenly, this year, they've done away with the attachment clause. You cannot attach, right? Nothing wrong with that. We cannot attach. Only those who have two numbers of Bowsers and you meet the other experience criteria would be there. So that part is nothing wrong. So I'm a new entrant. The question is, are my rights, if I have any, touched, affected on the touchstone of fundamental rights? If yes, I have a case. If no, nothing. Now, if I cannot attach a Bowser,
Let me ask you one question before you start. This is a every year phenomenon or
Every year.
every year? So on the last year,
my
say,
lordships,
did you attach your Bowser to anybody?
I'm a new player.
Yeah. So even as of last year, you did not have any experience.
My lordships,
So what you want today is that you want to attach your Bowser
my lordships,
because you cannot have the experience anyway.
lordships,
So you want that you should be allowed to attach your Bowser to one of the bidders,
my lordships.
as has been done in the earlier.
So what happens
experience.
otherwise is that if I cannot attach today,
Huh.
I would never be able to have that experience in point of life because if
How do you know what they're going to what the terms and conditions are going to be
Precisely.
next year?
if on the touchstone of that tomorrow they might have a clause of attachment, if that strikes a chord, then certainly they ought to have an attachment clause here because I need to participate. And this is not something I say to incorporate. This has always been there, but they have done away with it. Now, after we filed the writ petition, 17th is the date of opening of the tenders. On Saturday, they've come up with this corrigendum,
No, tell me one thing.
my lordships.
Suppose you have got one Bowser
I
only.
have.
One.
I have.
Now supposing you had two, then could you participate?
I am not on this round.
No. I'm just
I
my
I could not have. On the experience, I could not have.
so experience because of the experience criteria, you would not have your bid would have been
So I could not
disqualified.
have. Having two, I could not have.
No.
But under attachment, I
My
could have.
question is this:
Yes, no,
if you had two Bowsers,
my lordship.
could you participate in the tender?
Could not have. Now, by this removal or doing away with the clause, they do away with the birth of
Let
experience.
us see the clause. Let
My
us see the
lordship.
clause.
Page 37.
Yes.
What I'm on is that they do away with the gaining of experience. Experience can never
Let
be
me see.
bought.
Let us see what is required of a bidder. Let us see that.
Page 39.
It's 39.
Page 39.
Yes.
3.7.
Yes.
Each bidder. May I read, my lord?
Yes.
Each bidder can offer only two numbers of readily available 12 KL capacity oil Bowsers, oil tankers, as mentioned above in PEC BRC clause number 2.0 for 12 KL capacity Bowsers of model Tata AC 1613 cover or equivalent with minimum so and so. All the oil tankers, oil Bowsers offered must be in the bidder's name. In case of proprietary firm, it can be in the proprietor's name and similarly in the firm, in the partnership company name.
That's all.
Yes, there is no attachment clause here.
No, there is no experience required. You
No,
just need to have to.
I'm not on that, my lord.
So basically what I'm saying is, supposing you had two Bowsers, then you could have participated as a
No,
bidder.
no, that comes at 37, page 37,
Page 30.
page 37, page 37. The birth of experience is snapped by this non-attachment.
Yes, that's
3.1. The bidder must have successfully completed similar work over the last 7 years, reckoned from the original bid closing date of tender. Similar work mentioned above means the following. 1, the bidder must be in the business of providing services for transportation of petroleum products, hazardous chemicals, chemical salt solution in the central government, state government, public sector undertaking, E&P company, nationalized bank, public limited company for a continuous period of minimum 2 years, that is 24 months, under a single contract by deploying minimum one number of tanker Bowser having capacity not less than 9 KL each, or the The bidder must have experience of providing services of at least one number of attached Bowser's tankers having capacity of not less than 9 KL to All India Limited, that is experience of providing attached tankers Bowsers to the contractors engaged by the All India Limited for transportation of so and so for 2 years. So earlier, if I had attached, which was prevalent in the earlier tender, which I have annexed, then I gain it for this year. I did not attach earlier, but if you have an attachment clause,
Maybe for this Oil India only, but you could have done, you can gain experience from other state
Ma- I
government,
am-
other undertakings.
Under Roman one,
Huh?
under Roman one,
Ah.
3.1 Roman one, the option is available to him.
3 point under,
3.1
3.1.
Roman one.
Yes.
Similar work in any other.
Any other
organization.
field.
he understands
Why
why.
has it to be only
What,
All India
what
Limited?
I am on is
There's
that
so many companies.
He wants
that's
nothing from you.
that's not the case at all, with all respect, cumulative, I say that's not
The
the case
option
at
is
all.
always there.
No, that's not the option. What I'm on is that no, he is correct to defend. He has a choice what to say. But once I am aggrieved by non-incorporation of a clause which was prevalent all throughout, in which experience was to gain, forever it will be banned, forever it's gone.
That is there. You can always gain they want experienced persons and you can gain experience from other
The
places.
attachment thing, if it goes forever, now what they have done,
Also, the logic behind
Ah.
asking for the person who is supplying those tankers to be the owner of the tanker is also that tomorrow, if he is bringing someone else's tanker,
Ah.
something happens under the Motor Vehicle Act, the compliances or those liabilities are with that person
Ah.
who is not even a bidder here or not a contractor here. So we wanted to do away with that.
Correct.
We are saying
So
you are
the-
supplying your tanker. These are
nothing wrong.
petroleum carrying
that was
tankers.
there earlier. That was
Yes,
there
sir.
earlier. The
It has
persons
to be
who
yours.
would
So the responsibility is also-
absolutely, that was there
What
earlier.
is wrong?
That one who is attaching his Bowser must be the owner of the Bowser. He cannot guess it. Now the difficulty is, if Lordship, please, for a moment,
We can't even bid now.
If-
Doesn't have
if-
it.
they block the attachment thing, then only those players in the fray who are there, they would continue bidding forever.
No, you first
one
get,
comes
you,
in.
you go to some other place and get
Absolutely.
experience. Ah.
So here, if that
You
is,
go there.
but if that is what they say, that we block you here, you get experience from otherwhere.
No, it is here.
So
In 3.1 it is there.
3.1 is there along with the attachment thing prevalent,
Hmm.
3.1 is there with the thing prevalent. The
So how does
disjunction
it
is
matter?
arbitrary,
For those who are
Don't have
already
a
having
choice
their
to-
experience, it will be there.
But what I am on,
Sorry. You are not the author.
I am not the author, but
There
if-
is
if-
no
if-
arbitrary.
I don't find anything wrong in the interpretation.
but may I try to
You
persuade?
can
one
try
of-
your luck here at the division bench.
Not on that.
No, you have to try.
Look, may I try to rephrase my sentence 1 second?
Hmm.
May I try to persuade once? It
No,
means a
won't
livelihood to
change,
someone.
won't change.
But it means a livelihood to someone. Maybe I
It,
could not
you see, everything means a livelihood to someone or the other. It doesn't mean that your livelihood has to be based only on Oil India.
But-
You can go to any other state government undertaking. It says here, central government, state government, public sector undertakings, E&P company, nationalized banks. The whole world is in front of you. Why do you want to?
The Valivar refinery
put
is
your
there,
truck only
Gas
under one
Corporation
roof.
is there.
You can have 30 roofs.
They say that you provide there,
No case.
but attachment was not there. Attachment factory
Sorry.
is not there, Vinod. Attachment factory is not there.
What?
I must be a one who bids there, and then I get experience. While
Look,
Oil India
I
has-
don't know whether in the public sector undertaking of the central government or state government, they need 2 Bowsers or 1 Bowser or 20 Bowsers. I don't know. You have to say, you cannot just speculate.
The projections ought to be made is
And
perhaps not correct.
look, you are a new player. You cannot straight away put yourself in the category of Ambani or somebody like that.
Playing that.
Please remember your status there.
But I-
You are a new player.
Let those players dominate, Vinod.
That's
They
the
cannot
life.
harm my chance of participation.
Sorry,
That's
sir.
what exactly happening, Vinod. But may I read 3.1?
No.
May I read 3.1?
You're wasting time.
Perhaps not.
But
Perhaps
not to you, for me, you're wasting time. You can always try your luck somewhere else.
Very well. But they are opening tomorrow, day after tomorrow.
They-
tomorrow.
unfortunately-
But they have Bottleneck original.
Huh?
They Bottleneck original.
So what?
Now they increase from 2 to 3.
2 to 3.
2 to 3.
Very good. Let them make it 5 also. How does it matter? It is, you see, the end result is, it is for the public that they're doing this. It is not to make you money.
No, no.
You can make your money, no doubt.
But to see,
But it is for the general public that the Oil India is doing things.
And for transportation
Yeah.
of petroleum.
Yeah,
But you
petroleum
ask for
product,
experience
you want, you want a share of the pie, that's all.
one,
We want,
experienced people
we want to
having
get
their
up,
own
we want to
vehicles.
get our 1-2 liters of petrol in our car, that's
so
all.
what I'm saying is that, to
No, no.
seek for experience and not let experience being born.
You, yeah,
It's a gone, you know.
yes.
I have placed a judgment also,
Yeah.
paragraph 9.
He'll be
What,
CPO.
what have you got to say?
Only that aspect that ultimately we are the author, and this particular clause would otherwise show that there is no arbitrariness there. And the reason behind it is the only thing is that we want person to be a responsible person who will be able to handle the business. And tomorrow if something happens, the liability is with him because he is the
Ah,
registered owner.
Accountability can be fixed on
Yes,
him,
I
the
don't want someone
responsibility.
else's tankers transporting my crude oil and something happens and the contractor says it doesn't belong to me. Under the Motor Vehicle Act, it belongs to him. Registration is with him. Please go and find him. I don't want that. I want the things to be simple and clear. That's why I have brought this clause now. No more attachment business. You want experience? 3.1.1 is there for you. You have the experience, you come. You don't have the experience, I can't help it. I want my business to be safe.
Correct. Okay.
Paragraph 9 will also will see that it basically deals with this aspect only.
This Balaji,
Yes. Simple thing.
all those AFCON and all
Yes,
those.
yes, just that's abundant caution I brought. Then when it is uniformly applied and if there is nothing arbitrariness, so courts may not. Just that.
Anyway, what to do? Sometimes you have got to take the, the narrow road to come to that level. Anyway, I don't know. Right, heard Mr. S. Bani, learned counsel for the petitioner. Also heard Mr.
A Sharma.
A. Sharma
Standing
for
Counsel,
the
All India Limited.
standing counsel,
Standing Counsel, All India Limited.
All India Limited.
Appearing for all the respondents. Appearing for all the respondents.
Appearing for all the response. The petitioner's case is that the Oil India Limited used to float tenders annually for transportation of crude oil by bowsers / tankers by using 12 KL capacity bowsers, 12 capacity KL bowsers / tankers from various oil field locations in Assam and Arunachal Pradesh. If not, it is this for 3 years, not annually.
3 years. Yes, sir.
For not annually, for 3 years, For 3 years. Pusta. Next part. The petitioner's counsel submits that earlier a person who did not have the required number of bowsers to be a bidder for transportation of the crude oil could attach his bowser with the bid of a bidder or to the bid of a bidder who had the required number of bowsers and also had the other eligibility criteria required for participating in the tenders issued by the Oil India Limited. The bidder, the person who attached his bowser with a bidder could thereafter count the experience acquired could count his participation in the tender process as experience for participating in the next bid to be made by the Oil India Limited. However, by the new tender number TDT 7868 P25. The Oil India Limited has done away with the concept of a Bowser owner attaching his Bowser with the bid of a bidder, bid of an eligible bidder. Thereby eliminating any chance for the said person owning a single Bowser to gain any experience for participating in any Oil India tender for transportation of crude oil, etc. Full stop. Next para. The petitioners council submits that in terms of the new tender number CDT 7868 P25, all bids must no 25 comma the bidder must have a minimum of two Bowsers, two or three,
Now they've increased to three.
two
on a
Bowsers,
Saturday.
two Bowsers slash tankers, comma, which has been increased to three
It
Bowsers.
says 2 or 3, not 3, increase to 3.
It is his submission, how does it matter?
Yes, but then the correct version is that.
Okay, which has been, no, two or three Bowsers, it is
Or 3.
two or three Bowsers slash
Consonant and
tankers,
allowed.
Full stop. He submits that the Bowsers slash tankers have to be in the name of the bidder. And the bidder cannot attach the Bowser slash tanker of any other person as part of his bid. Full stop. Full stop. He submits that the doing away with the clause for attachment by the Oil India Limited
Restricts new players and cartel is formed.
Huh?
Restricts new players from entry and the cartel is.
restricts new players like the petitioner
And
from
favors cartel formation.
participating and encourages the formation of a cartel who will
Dominate the people.
dominate dominate the tender proceedings. Full stop. He accordingly submits that a direction should be issued to the respondents to cancel the tender and direct them to issue a fresh tender allowing new players like the petitioner to attach their single Bowser with the bid of the bidders who can participate in the bidding process. Next paragraph. Mr. A. Sharma, the learned counsel for the respondents, on the other hand, submits that the Oil India Limited have done away with the process of attaching, or the process of the bidder attaching the Bowsers of other persons for the sake of accountability and fixing of responsibility in the case of any
Untoward incidents.
untoward incidents that may happen
That is, have to
to
happen.
the browser that is being used, browser of somebody else being used by the bidder.
Something that will be in conflict with law. In that
He
situation,
submits that even as per, even pertaining to accidents. He submits that events pertaining to accident would entail the All India Limited to run after some other persons other than the bidder. Under the Motor Vehicles Act and even in cases pertaining to the Motor Accident Claims Tribunal. Pusta.
My one-liner reply to that. It is self-conflicting as in page 67. It said the earlier round, the bidder and the owner of attached
that is
browsers
not in
must
question here.
own the offered browsers in their.
Anyway, Mr. Council, anyway.
That may be there, Mina.
No, no,
But-
this is his submission. He can submit anything. You please don't counter. He wants to submit, let him submit anything.
And the second issue will be regarding the experience. Clause 3.1.1
Ah.
provides the avenue for him to gain the
Next
experience.
para. The council, Mr. A. Sharma further submits that as per 3.1 of the terms and conditions of the
Yes,
tender, comma, the bidder can always gain experience from providing services for transportation under the central government, comma, state government, comma, public sector undertaking, comma, what is ENP company? ENP company. In 3.1, it is ENP.
Yes, sir.
ENP company,
Just
comma,
find out.
nationalized banks, comma, public limited company for a continuous period of 2 years under a single contract by deploying a minimum of one tanker/bowser having a capacity of not less than 9 KLE, 9 KL.
Exploration and production company.
Exploration and production
Basically,
company.
to deal with crude oil exploration and production. Any that kind of
Uh-huh.
company.
Pusta. He accordingly submits that. The Oil India is Limited is the best person to understand and appreciate its own requirements. And that it must have the freedom to make contracts on its own terms. Accordingly submits that the interpretation of a tender document should be left solely to the uh, uh, solely to the author of the tender document, unless the same is arbitrary, unreasonable, malified, or is biased. In the present case, he submits that none of the above have been attracted, and as such, the writ petition should be dismissed. Full stop. I have heard the learned counsels for the parties. Full stop. In the case of Balaji Ventures Private Limited versus, okay, you start from the beginning. You start from AFCONS. You say in the case of AFCONS, then you write in the case of Vidarbha, then you write in the case of Balaji Ventures Private Limited. Okay.
Yeah.
I'll pass the order. I'll complete it later. It'll take time. So should I say dismiss now or should I make it CAV?
If your lordship is delivering the judgment.
I have to deliver. No point keeping it pending. I'm not going to.
Yes.
You want to go straight, I think, because you want me to issue notice, I can issue notice. I'm not no stay, but so no point. No point. Better you.
Reserve it for judgment and deliver it.
See,
Tomorrow is the mid okay.
what to do, I have got, there are around 50 other cases behind you waiting for similar kind of orders. My throat is also gone. The more I speak, I'm coughing more.
Oblige, Your Lordship.
Miss- Mr. Goswami, so that case, new tender. So- So contempt will, I'll just list it today and I'll just say that I'll close it. So Mr. Goswami will be for the thing, just right. Mr. U Goswami appears for the petitioner. And who appears for the respondent?
For 1 and 2, madam.
Mr.
P.S. Bhattacharya.
Bhattacharya appears for point number 1 and 2. That's all. Others too, huh? In the order passed in the main case in WPC, huh, so the contempt petition stands closed.
Hello.
Oblige.
I think one. May I please, Your Lordship? My lord,
Acha, you put this in the file. Or what is this? Here.
my lord,
Yes.
I have received a copy of the affidavit in opposition filed by the respondent, my lord. I pray for some time, my lord, for filing the reply, my lord.
What is that? What remains here, Mr. Counsel?
My lord, an additional affidavit also filed by the petitioner, my lord, that is not also in record, my lord.
No, but what remains? You have basically, you are supposed to, your extra rewards is based upon the number of liters that you sell.
Right.
You have fudged the records.
My lord, in the,
It is clear. So one is the amount payable due to the fudging, and the other amount, that 1 lakh, 1 crore something, is basically a penalty. Now, can I change the penalty amount?
my lord, including the payment which paid by the petitioner, my lord. That includes the penalty, my lord. Because what the respondent authority has suffered losses, my lord. That amount the petitioner has already paid, my lord.
What to do, Mr.?
My lord, I only praise for 10 days time of filing the reply, my lord. I'll kindly grant some time, my lord.
Look, we've even allowed you, actually, I should not have, I've even allowed you to run your petrol pump. We should not have allowed you.
My lord,
And that stay order that allowing you to run the petrol pump, this court has not extended it, by the way. It has not extended that thing.
But we have provided,
We have provided.
we're complying with that.
So they are giving you all the assistance.
my lord, I only pray for.
So what can be? Something is going on outside the court. And now everyone is excited now, all running out. Take a video, show me later on. Anyway, so what is to be done? There's an arbitration clause also.
My lord, but as per what I understood, my lord, the arbitration clause, the dispute which has been arises between the petitioner and the respondent authority, that does not cover, my lord.
Right?
My lord, the arbitration clause says, my lord, that if any dispute arises, my lord, regarding the agreement, it was executed in the year 2012, my lord.
So these extra rewards does not pertain to that. It pertains to
My lord,
sale.
I only pay for 10 days time, my lord. Only 10 days time for filing the reply, my lord. Thereafter, my lord, lots of.
Okay, let him find what. But you've got an appeal. Can you come to some sort of compromise or something?
In fact, madam, we have called him for a discussion, and in the discussion, we asked them that they satisfy us that we are wrong. We, in the affidavit, we have said, madam, that he could not produce us anything, and we have filed a very detailed affidavit.
I know. I do not know what he's going to produce. These are questions of fact,
My lord.
which you have not denied.
Only the thing, my lord, that whatever comes in the additional, my lord, the affidavit in opposition, my lord,
I need some time for filing and.
Okay, right. Last chance.
My lord.
So we have kept it like this pending since long time.
My lord,
Should we issue notice?
My lord, notice has not been issued as yet, my lord.
We'll issue notice, I think. Heard, Mr.
DJ Halal.
DJ Haloy, the counsel for the petitioner, who submits that he needs 10 days time to file a reply affidavit to the affidavit filed by the respondent. Respondent. Issue notice returnable in 10 days. Mr. Who accepts notice?
And
Miss
miss and
N. Datta accept notice on behalf of
all the response.
all the respondents. List the matter. No, the petitioner shall submit the reply affidavit within 10 days. List the matter after the vacation.
I think to. Beg to the lord.
So what was the problem?
My lord, the problem, my lord.
No, outside.
Problem is Mr. Sahela is having a problem is, I think, he is having a fainted there.
Oh,
So Sahela.
oh.
So
So he's been taken to the hospital.
Oh, yes, yes, been taken to the hospital now. Maybe stroke or
Ah.
pressure may be high. That's.
Yes,
Now, my lord, the instruction which the lordship has been sought from the forest department is saying that it is the deputy commissioner who is the competent authority and he has to forward my application for environment council, my lord, from the SEIAA, my lord. Now, what has happened, my lord, after that, I have gone to the DC office to file my applications, my lord, and they are not accepted, saying that we do not have the file. Now, that is the problem what I am facing. The work which has been having an extended by the PWD has been stalled because of I could not procure the clay, my lord. Now, my limited prayer, my lord, will file today, my lord, your lordship may direct to keep my applications, take my application forwarded immediately to the committee, my lord, so that clearance may be given and a time frame may be given, my lord. But within so and so, and my lord,
so you will write representation to the DC
yes, my lord, I have.
and DC will submit it to that authority. Okay, right.
Within 10 days, my lord, your lordship may.
Look, right. Heard Mr. P. Bora, Leonard, senior counsel for the petitioner, assisted by H.K. Sharma. Also heard Mr. R.R. Govai, learned counsel for the forest department,
Response number 5.
and Mr. G. Bokaliel for the.
DC is not a party here. That's the issue.
This is not a party, but whatever it is, by the instructions.
But then he cannot accept. Okay, anyway, I'll pass the order. And Miss H. Barwa on behalf of Mr. P. Nayak, counsel for the PW. Right. Mr. P. Barwa, P. Bora, the learned counsel for the petitioner submits that the petitioner needs to transport clay for his contract work for filling up an embankment. First off, however, the permission given to the petitioner for transporting clay had expired on 15/8/2024. The petitioner's counsel submits that in terms of the work permit given to the petitioner given by whom? Given by the public, where is that order? No, page,
27, my lord.
page,
27.
given by, given on 26/10/23 by, no, given on,
Regarding the work orders,
yes,
work order is of 27, page 27, right? Which has been given by the PWD.
page 27. Wait. Work order is at page 27.
27, Milord.
And where is the work permit?
28, Milord.
Okay, this right. The petitioner's counsel submits that in terms of the work order dated 17/8/2023 issued by the chief engineer PWD bracket roads, SAP for construction of embankments and so this is in the subject is page at page 27. It is it. From here to here. Okay. The petition and the work permit dated 26/10/2020, no, dated 10/23, 26/10/2020. Which was valid till 15/8/2024, the petitioner could extract 10,000 cubic meters of clay.
Allotted was 10,000, but I have extended only
Stop.
9.
However, the petitioner extracted only 995 cubic meters of clay. Full stop. Next paragraph. The petitioner's counsel submits that the petitioner's representations dated 12/11/24 and 16/11/2024 issued to the additional district commissioner, mines and minerals, Sibsagar and DFO bracket T, Sibsagar Forest Division, Sibsagar have not been decided till date. So we direct the additional district commissioner to send this.
My lord,
The deputy commissioner is a competent authority, your lordship.
Okay.
Deputy commissioner and the usage agency must obtain environmental clearance issued from CR after forwarded application from the district commissioner. your lordship.
Okay, anyway. Then Mr. R. Gogoi, learned R. Gogoi,
RR.
learned counsel for the forest department, submits that the extension of the petitioner's permit for extraction and transportation of clay would have to be decided by the State Environmental Impact Assessment Authority, which is under the forest department. He submits that
At point 1, your lordship.
as per the principal secretary to the government of Assam, Mines and Mineral Department, Dispur, notification number PM/8/84/PT-Roman 3/14- dated 3/8/2021. The concerned deputy commissioner is the competent authority for all works related to ordinary clay. Full stop. The user agency must obtain environmental clearance certificate issued from the SEIA, Assam, after the application is forwarded by the district commissioner. Full stop. Next paragraph. On considering the submissions made by the councils for the parties, this court finds that the district commissioner has not been made a party in this case. Full stop.
your lordship may keep it pending, below the matters. I'll take, your lordship may direct deputy commissioner to board because it has come subsequently, because I will add with the permission to add this thing. My lord, your lordship may keep the pending and make it a time that today I'll file this application and the deputy commissioner will take necessary steps, my lord, to forward it to the CI, and CI will dispose of my application within a stipulated time, my lord.
Very well, sir. Gustav, this court is of the view that the district commissioner, which district? Sibsagar should be made a party and accordingly, the district commissioner, Sibsagar, is impleaded as respondent number six. The petitioners have submit a a corrected copy of the course title to the registry within the course of the day. During the course of the day.
My lord.
Gustav. Mr. G, issue notice to the district commissioner, Sibsagar. Mr. G. Bokalial accept notice on behalf of that is point number six. Gustav. That is Sibsagar, DC Sibsagar. Next para. In view of the notification number issued by the principal secretary of the government of Assam, Mines and Mineral Department, dispute. This court is of the view that a fresh representation should be submitted by the petitioner to the district commissioner Sibsagar for being allowed to extract clay by extending the permit provided to them earlier. Gustav. Accordingly, the petitioner shall submit a representation to the district commissioner, Sibsagar.
By tomorrow, my lord, that is by 17th.
Then I leave it up to you.
My lord.
Within, for extension of the permit for extraction of clay within a period of 2 days from today.
Hello.
Full stop. In the event the permit is provided, the representation is submitted to the district commissioner, Sibsagar, within 2 days, the district commissioner shall thereafter forward the same to the SEIAA. Is it?
State
To the
SEIAA.
to the State Environmental Impact Assessment Authority within a further period of 2 days thereafter. The SCIA shall thereafter take a decision and convey its decision to the Forest Department. To the which authority?
Let it go to DFO, Lordship.
To the DFO Sibsagar Forest Division, who shall communicate the same to the petition. The entire proceeding should be concluded within a period of 2 weeks
Very good.
from the date of receipt of the petitioner's representation by the concerned deputy commissioner, district commissioner. The writ petition is accordingly disposed. When did you supply this?
That's it.
When did you supply the labor?
This is pertaining to 2019 Lok Sabha election.
Okay. Mr. S.K. Das, learned counsel for the petitioner, submits that the labor supply cost of rupees 2,18,580 has not been paid. Issue notice returnable in 4 weeks. Mr. G. Bokalial accepts notice on behalf of all the respondents. Respondent number 3. What about others?
On finances there and election.
Miss
RM Baroy, Lordship.
for
One.
One.
Respondent one.
for B, Mr. B, what about 2?
R Dubey AP.
R. Dubai.
Dubey.
Mr. R. Dubai accepts notice on behalf of respondent number 3. Extra copies of the writ petition be provided to the response council. List the matter. Just write, registry to reflect, SC, elections, State Election Commission
And finance.
in the cause list, huh?
Finance. Leave it to you, Lordship. It's only on that where I can be disqualified for life.
Yes,
I will not object to that, I know.
What?
He's
Because
restricting
it's
me to
over.
object.
Huh?
He's restricting me to
No, tender
object.
is over. I said tender is over. I'm not getting it. Tender
Everything,
is over.
this writ petition is absolutely based on assumption, what may happen in future.
No, 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 no.
Only thing is that this part is over. Because whatever the contention of the writ petitioner, this part is already over. Technical bit, financial bit, all part is over. Now, any cause of action if in future arises, then only he can come before this honorable court.
No, but then he's cancelled. Why
That
should,
was-
why should, has the work order been issued?
No.
But that has not been issued.
He submitted his bid.
Yes, submitted by me.
Technical bid was cancelled.
Cancel.
Then,
Actually, he has very specifically made a mention that he is otherwise not eligible for this particular.
No, 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 not eligible is wrong. What I said, had you opened my financial bid, I would have not been the L1, I would have been the L2.
ah,
That is my fairness. You cannot know that. I'm fair to the court.
you see, but for the future, we have to clarify this. He's going to get another problem.
Yes, Lordship, that can be done up to that extent.
And this is the ethics code.
Up to that extent, court may pass an order.
One cannot be blacklisted for life. Sorry.
Problem is the more I speak,
We are extremely sorry. Lordship,
the more I speak, the more thing is
but it
happening.
can be
And
saved.
the whole day,
It can be kept
It can
saving.
be saved.
Nothing will happen
It can
now.
be saved.
It can be kept.
no, but the problem is keeping shavy. I'm burdening myself. The big problem.
150 quarter will do.
Hmm. No, I will tomorrow the same thing. We'll try. Sorry. Right. Misheard Mr. S. Banik, learned counsel for the petition. And Mr.
SP Chaudhary.
S.P. Chaudhary for all.
I will not appear for all. I will appear for this record number 2.
He is the main person.
He's the main person.
For number two. The petitioner's case is that the petitioner participated in a tender process. Just take it down, page 35. Okay, I'll just mark it. From the second line, okay? Okay. Mr. S. Banik, the learned counsel submits that the financial bid of the tenderers have been opened and he has come to, and that the petitioner's bid,
Though not open, I know.
though not opened, is known to him. First up, as per the petitioner's financial bid, he is L2.
L2.
L1 has been given or what?
No,
Then,
he will have the.
okay, first up, L2.
Last
First up, next, Mr. S.P. Chaudhary, the learned counsel for the respondent number 2 submits that the tender has been awarded to the tenderer whose bid was L1. First up, accordingly, the writ petition has become infructuous insofar as the petitioner stakes the claim to be awarded the contract. Full stop. Next para. So it is not disputed by you that his tender was disqualified due to his blacklisting for
Exactly.
3 years in 2000.
They accept.
And this particular thing is already annexed in the writ petition also.
Fair?
Page 33.
Okay. How do we know it's for 3 years? That 2012,
That-
was it?
Any other case, I'm coming with that plea only. Even the IIT was there. I got tenders from IIT also.
Okay, right. Mr. S.P. Gupta, the learned counsel for the respondent number 2, submits that. He has got no quarrel with the submission made by the petitioner's counsel that the petitioner's bid had been disqualified due to the petitioner having been blacklisted in the year 2012. That's all. Next, I have heard the learned counsels for the parties. Full stop. The question. The issue here is whether the petitioner's bid could have been rejected only on the ground that he had been blacklisted in the year 2012 for a period of three years, which had subsequently been over by the year 2050. The answer to that is a resounding no. Inverted commas, no. Huh? Further, the manner in which the petitioners, no, the reason for which the petitioner's bid has been rejected on the ground that he had been blacklisted earlier amounts to coming to a finding that the blacklisting of the petitioner in the year 2012 would have to be considered to be in perpetuity. Next paragraph. In the case of MS Chauhan Builders Rai Bareli versus the state of Uttar Pradesh and others, comma, SLP number 32840/2018, which was disposed of
16th August 22.
on 16/8/2022.
Here no period was given. Supreme Court said 5 years. Last
The Supreme Court has held that one cannot be blacklisted for life. Full stop. The order of blacklisting, to the extent that it has not specified the period, cannot be sustained. Since the order was passed way back in 2013 and the writ petition was dismissed on 5/9/2018, the Supreme Court deemed it appropriate to exercise its powers under Article 142 of the Constitution to pass an order of blacklisting the appellant for a period of 5 years from the date the order was passed. Full stop. Next paragraph. The above clearly shows that there cannot be an order blacklisting a person for life. And in this case, no, full stop, and not and, full stop. The above being said, the petitioner had not been blacklisted for life, but had been only blacklisted for 3 years, comma, which was over in the year 2015. Consequently, the respondents could not have acted upon the could not have rejected the petitioner's bid by acting as if the blacklisting order of 2012 would have its effect beyond 3 years. In view of the reasons stated above, the rejection of the petitioner's technical bid by the respondents is hereby set aside.
Further, my rejection only goes, nothing else. Further, if the L1 backs out, my financial bid be okay.
Full stop.
An offer given.
Ah.
If L1 backs out.
In the full stop. Though as the counsel for the respondent has submitted, respondent number 2 has submitted that the contract has been awarded to L1 has been awarded to the bidder the tenderer whose bid was L1, comma. This court is of the view that the present writ petition is only of academic interest as on date. Full stop. However, in the event that the respondent number in the event that the tenderer whose bid is L1 does not accept the contract for whatsoever reason, comma, the respondents are directed to open the financial bit of the petitioner and consider the petitioner for the said contract work. The writ petition accordingly disposed of.
It will be more than 47.
Yes, madam.
Your lordship, again, it's a devoter case.
Huh?
So it's a devoter,
47 is devoter.
devoter case, your lordship. He is the petitioner, your lord.
Only one thing, you're saying Ashish Kumar Das, correct? Now come to page 46, 47. Come to page 46.
Additionally.
Oh, which, I've not received the additional affidavit, your lordship. I have only till. So that,
Yes.
that's why, yeah.
Yes, give a copy.
Lordship, I'll provide.
When?
Lordship, today.
Come to page 46,
Lordship,
Ashish Kumar Das, correct?
Lordship.
Now you come to page 45. What is the name?
Sir, Ashish Das.
Huh?
Ashish Das.
So are they the same? Ashish Das and Ashish Kumar Das, can they be the same?
Lordship, they have,
Everything else seems to be okay, but there's a discrepancy in the name.
Lordship, they have denied to provide the certificate
Huh?
copy of. They have denied to provide the certificate copy of extract 2011 voter list, Lordship. And we have applied on, the petitioner has applied on 22/8/2024, Lordship.
No, Mr. Counsel, I'm not on that. I'm on your name. The writ petition, your name is Ashish Kumar Das. Page 45 is Ashish Das.
Lordship.
There is no Kumar. Should the authorities look into this aspect also?
Your
Or what?
lordship, if I may submit, lordship, so there is nothing on record that has been given to us which shows that the petitioner has been marked a devoter. They mention about a memo, but the memo is also not attached. So nothing on record to show that he has been marked a devoter anywhere. So if we don't see any document, it becomes difficult to.
That is
respond to
true.
that.
No, but yes. Where is the D voter? Only on page 46. You have put D somehow, but it's been 46A. Look at 46A. You have not been given the writ
No.
petition. Or
No,
the
we have the
additional.
petition, we don't have the additional affidavit. So we don't know the document.
Lordship, I'll ask my senior, Lordship.
Huh? What?
I'll take instruction from my senior, Lordship.
Who's the senior?
DP Mondal.
You give this by 2 o'clock.
Lordship,
This additional affidavit.
Lordship.
What is your name?
A. Thakuria.
Mr. A. Thakuria, counsel for the petitioner shall give a copy of the additional affidavit to Miss
P. Barwa, lordship,
P. Barwa for
is election commission.
the
Is
election commission by 2 p.m. today. I will take it up at 2 p.m.
Lordship.
obliged. Much obliged.
Highly obliged.
48.
Hey, please, your lordship, this matter will be taken at 2, lordship. I am not in this case. I am appearing on behalf of Mr. P. Burdubai.
Okay.
That case.
Yes,
Here in this case, my lord, first of all, my lord, there notification, my lord. It should not be applied in this case, my lord, because my lord, the respondent number, the respondent number 3, my lord. It Yes, quoted the amount, my lord, the price, my lord. That is not permissible as per the it close, my lord. Here, my lord, kindly come to page 30, 37, my lord, the close of the bid document, my lord. Yeah, my lord, quoted bid value of beyond 10%,
page 37.
my lord,
Yes,
29.3, my lord, 4, my lord. The quoted bid value of beyond 10% below of the estimated amount shall not be considered for award. So, my lord, in this instant case, my lord, the resolution number 3, my lord, admittedly, my lord, he had quoted the bid below beyond 10% below, my lord. So, my lord, ultimately, my lord, his bid could not have come to the consideration, my lord, because he is, my lord, financially not responsible, my lord. Here, my lord, it is specific, it is there, my lord. Below of the estimated amount shall not be considered for award. The rates quoted by the bidder beyond 10% below lower than the estimated rate shall be rejected as non-responsive. And once a bid is non-responsive, my lord, subsequently corrected by the employer, my lord, that cannot be, my lord, because it is preliminary, my lord, violated clause, my lord. Moreover, kindly come to page 36, my lord. Another clause is there, my lord. Clause 26.3, my lord. If a financial bid is not substantially responsive, it will be rejected by the employer and may not subsequently be made responsive by correction or withdrawal or non-confronting derivation or reservation, my lord. So, my lord, ultimately, my lord, he should not come into consideration, my lord, because outrightly, my lord, his bid is, my lord, non-responsive, my lord. So, my lord, financial evaluation, he should not have come, my lord. So, definitely, my lord, now, my lord, they are raising the one issue, my lord, memorandum of 2004, my lord, circular, my lord. That is not also regarding to this department, my lord. That is separate department, my lord. PWD, my lord. It is, my lord, urban housing department, my lord. And there cannot be a violation of the bid clause, my lord. Now, my lord, how, my lord, they are, my lord, legalizing the bid of the respondent number 3, my lord, who is financially, my lord, non-responsive, my lord. And clause 3, my lord, is specific is there, my lord. Is specifically mentioned, my lord. If a financial bid is not substantially responsive, it will be rejected by the employer and may not be subsequently be made responsive by correction. My lord, it is their own thought, my lord. And moreover, my lord, kindly one thing, my lord, if his bid is considered to be rounded, my lord, then, my lord, he will be equal to the petitioner, my lord. The petitioner, he will be alone, petitioner will also be alone, my lord. So, my lord, mere violation on the violation ground of the bid clause, my lord, the respondent number, bid of the respondent number cannot be considered, my lord.
and you are relying upon that.
Yes,
notice.
because lordship that the petitioner counsel for the petitioner pointed out page 37 that 4. Because at the time of consideration for award, so when we have to consider the bid price, lordship, we have to round it up. lordship, to the
Okay,
nearest-
At the time of award, my lord.
let me decide, let me decide.
At the time of award, my lord, not at the time of ranking, my lord. At the time of award, my lord, they can round it up. But at the time of ranking, my lord, they cannot, my lord. Because mere 1% makes difference, my lord.
Because page 80, lordship. if you-
Whatever.
Okay.
Ultimately, below 10% below, my lord. So, my lord, ultimately, it will be financially non-responsible.
Okay, right.
And we are following this notifications.
Okay, right. Heard Mr. S. Hawk, learned counsel for the petitioner. And Mr. S. R. Barwa, learned counsel for the
Respondent number 1 and 2.
respondent number 1 and 2. Mr. S. Hawk, the learned counsel for the petitioner, submits that in terms of We just take this order dated 2/12/24, first para, huh? Second para, third para. Okay. No, just take 1 and 2, okay? And number 3, the petitioner's counsel submits that where is the price, Mr. Hawk? Your bids page,
Page 80, Lord.
Page 80, madam.
page 18,
80.
submits. Page 18, where is that? No, page 18, no, where is your bid and his bid and that respondent number 3's bid?
My lord, this is the list, my lord. Here all the.
No, what is the amount? Your
Estimated
amount, estimated amount.
Page
your-
19, lordship. Page 19.
The bid amount, he has bid 1 lakh, he has bid 2 lakhs, he has bid 3 lakhs. Where is that bid amount?
That is the list, my lord.
Where?
That is the statement, my lord.
Page
Page 80, my lord.
80, 80.
80.
Oh, I was looking at 18. Okay.
80.
Okay, submits that the bid of the bid of the petitioner and the respondent number 3 is as follows, huh? Number 1, you put down there, petitioner, you put petitioner dash. How much is the amount?
My lord, petitioner's amount was
7785
900
7785 900
dot 10.
point 00. Petition number 2, 7785 899.69. Huh?
Petitioner's bid is
No,
exactly.
just say that, huh? Don't say that. Just say the petitioner's counsel submits that in terms of that you correct. You put it there. Then you say after that. You put that. Then the petitioner's counsel submits that though the bid of the respondent number 3 was
Below P&L.
below 10% of the estimated amount as provided in clause 29(4) of the NIT. The petitioner, the bid of the respondent number 3 has been held to be L1 and the bid of the petitioner has been held to be L2. He submits that once the bid of the respondent number 3 is below 10% of the estimated amount in terms of clause 29(4), capital 4, huh? Roman 4, comma. The financial bid of the respondent number 3 would have to be considered to be non-responsive in terms of clause 26 Roman 3. Big, huh? First one. Accordingly submits that the acceptance of the bid of the respondent number 3 by the chief engineer technical Department of Housing and Urban Affairs Guwahati, wide letter of acceptance dated 20/11/2024 for construction of for the contract work should be set aside. and the said work and the said contract work should be allotted to the petitioner. Gustav. Huh? That's your case. Next, Mr. S.R. Barwa, the learned counsel for the. For
For
all the
number
for-
1 and 2.
respond number 1 and 2 submits that the bid of the respondent number 3 was 31 paisa less than the was 31 paisa below 10% of the estimated amount. Gustav, however, the tender committee had to follow the notification dated 21/9/2004 issued by the Commissioner and Special Secretary, Government of Assam, Public Works Department, issued wide number CRD 119/2003/5, wherein rounding up of the bid price to the nearest rupee value was to be given. This number, no, wide number, you make it here. Notification numbers also dated. Huh? Next. The counsel for the respond number 1 and 2 submit that in view of the rounding up of the bid price of the respond number 3 to the nearest rupee value, there has been no violation of clause
29.4.
clause 29(4) of the NIP. Full stop. He accordingly submits that the writ petition should be dismissed. That's all. I think anything else?
Yes, moreover, that bid capacity of the private
Okay.
respondent is,
Okay, right. Before that, you say, he also submit the learned counsel for the respondent, also respond number 1 and 2 for the submits that the bid capacity for that the bid that besides the above, the bid capacity of the respondent number 3 was significantly better than the bid capacity of the petition.
moreover,
Next
Lordship,
para.
one provision is also there, 29 Roman 5.
Huh.
Where in case of more than one bidder stand as L1 as per a statement of the financial bid, then the employer will decide and allot the award of contract to bidder, whoever found suitable, so analysis to carry out the contract. So that right
My lord,
we are having, Lordship.
Okay.
It should have been come from the respondent number 3, my lord.
Anyway, this what you just said now, bid capacity, is it in terms of clause 5?
Yes, yes.
Okay, what,
29 plus 5.
whatever, that one says so, bid capacity, in terms of clause 29(5).
Roman
Ah,
5.
that's all. Next, I have heard the learned counsel for the parties. Clause 26(3), page 36. And clause 29(4) and 5. Page 37. Are reproduced herein below as follows. Hearing concluded, judgment reserved.
My lord,
Coughing to it.
respondent.
Huh?
Notice was not yet issued to the private respondent.
We'll see. Whether order reserved,
My-
whether to
Oh, yes.
continue,
Fine.
order reserved. No, order reserved.
My lord, 50 is also. Sir.
Huh?
50, I cannot 50 is also.
50, but where is the page?
Essentially, work order, construction work is different.
One group
Maybe,
one
maybe. Basically, the issue is the
But
same.
Lordship, they have
There, the amount, the bid amount is again at page 80, huh?
Yeah.
Others, everything will be the same.
Also, we have awarded the contract to Nayan Judi Talukdar, but they have made him as a Narayan Judi Talukdar wrong.
It doesn't matter. It's a small mistake, hardly matter.
So this is the third round of litigation, my lord.
My lord, in this case, lordship, I have filed caveat lordship. Lord, the copy has not been given lordship.
Huh?
My lord, I have filed caveat, my lord, caveat number 116624. It is filed on date 2011-024.
Writ petition?
My lord, but may be taken up on Friday, lordship. And in the meantime, they will serve.
Fridays too. Why last day? Why do you want to do last day?
Then my lord, 19, my lord.
Just now, right
You give it just now.
now.
You give it right now. We'll take it up at 2 then. He can read during that time. Yes, of course.
Lordship is maybe taken on 19 lordship.
No, 19. 19. I'm sitting for a short time only.
Right now, my lord, because of the prayer and the earlier order.
Yeah. I don't know. Okay, whatever.
Now, since he's filed a caveat, we can give right now, my lord.
You give him a copy now.
Yes, it's a fact noted. Yes, a fact.
Lordship, I have not gone through the contents.
It's
of the
okay. We'll all go through together. I'm not. Everyone will go through
Then
together.
my lord, it may be taken at 2 lordship.
No,
I have some difficulty. I'm suffering from fever, my lord.
yes, I have a fever. I've got sore throat. Actually, not even sore throat. The doctor told me that you've got lawyers nodules or something like that. Lawyers, singers, they have that because they have, something. Because they're using your vocal cords too much.
I also stand on the same footing, my lord.
Then tomorrow.
And I don't know why politicians are not having it. Then. They use their voices more.
The restriction on our part, that's why.
Then tomorrow, lordship.
Huh?
Wednesday, lordship, Wednesday. Others matter also take some.
So one day I will not be available, lordship. Sorry,
Wednesday.
lordship.
Okay, you tell me what is the case.
This matter, in fact, your lordship will find. These two persons, admittedly, he is the highest bidder. That is my line of he is the highest bidder. What is the rule is that my lord clause 16, it says that if somebody applied for 2 bidders and he withdraws in what respect matter, then he is not available for 4
If he applies for 2.
2
Huh?
and withdraws against 1,
Ah.
suppose he will do 1.
Huh.
After that he won, then that money will be forfeited, everything will be forfeited, and he will be barred from participating in the consecutivity provisions. This is the case. Plus, we have found the co-pattadak minor. Co-pattadak as per rule is clause 8 minor. He must take the objection from the co-pattadak. Now here, minor, we have filed, as per your lordship's order, minor, we filed a representation. Representative we filed, they have reposed the representation, informing, first they inform minor that this money has been given, so he is to be given settlement. Then they inform that clause 16 is not applicable and co-pattadaks are not there, land stand in his own name. But we have given an access showing that the land which he has given, it also shows the name stands in the name of some other persons also. So on 2 grounds, one ground is that he has been barred, and other ground is he has not taken no objection from the co-pattadak. So that 2 points, if they are satisfied, I have nothing to say. By this time, he has taken possession, my academic. In that case, also notice may be issued, my lord. Stay, madam, your lordship may see the later, my lord. Now he has taken no possession, my lord.
Clause 16, lordship, the earlier round of litigation, page 77.
Yes.
Lordship, may kindly have a look, clause 16 for a moment, page 24, the NIT condition.
Page 60, yeah, my lord.
Page 24, my lord.
Page 22.
Lordship, got it, my lord?
Ah.
Clause 16, may I read, my lord?
On scrutiny and finalization of valid tenders, withdrawal of tender by any participant will attract not for forfeiture of BMD, but said participant will also be debarred from future participation in any tender issued by the IWT. It's future participation, my lord, from now onwards. So that ground, I am submitting this matter will be dismissed. From in earlier round of litigation, lordship, page 77, I have submitted before my lord, paragraph 4, my lord.
Future participation.
Yes, my lord.
Out here, he participated in which ones? In which,
This same tender process of the 2022 February.
no, no, the tender notice, where is the tender notice?
This February, lordship.
Tender notice is my lord 28 to 24.
Tender notice 8 to 24.
Then
Same
you'll also kindly see my lord.
Several paragraphs.
So he worked, he applied for two,
Yes, my lord.
so he withdrew in one.
One. And then for future participation, we will debate.
Just page 66 would make it clear, my. Woodwell part is there, your loss. Page 66, 13, my lord. Page 66 plus 13, my.
Yes.
Your lordship, got it. This is the, my lord, ferry in question, my lord. As per the comparative statement, it is found that the 6 bidders have participated in the tender process for the settlement of so and so. All the bidders have deposited the record so and so. The name of the bidders, your lordship, D is the respondent of 5. D. Then you will can see one bidder, Usman Ali, that is the respondent of 5. Your lordship got it, man. Has withdrawn his tender after opening the financial bid. The tender committee decides to forfeit his earnest money deposited with the tender, and the tenderer has been prohibited from submitting any tender in IWTU for a continuous period of 4 years. That is for the calendar year 2024, 25, 26, 27, as per clause 16 of the NI.
Yes, my
So
lord.
here future is not, there's a continuous period for the calendar year 24, 25, 26, 27.
Yeah, the prospective effect, it shouldn't be retrospective, my lord.
But he has already submitted it
Madam?
prior to this. Did he, now he has applied for another tender, another work, another
one.
ferry.
Yes.
Which one is that?
That ferry, that is my lord, you also pay. Yes, my lord. Six.
Clause 13, lordship, that paragraph he has withdrawn.
Oh, my.
yes.
Yes, page 60,
13,
page 60. Serial number 4. There was file, my name is serial number 2, his name is number 4, but his first to that one.
So out here, so we'll have to, we'll issue notice. That's
lordship,
all.
will file affidavit.
Only my lord some short period of time, because already they are taken possession of it.
I heard Mr. H.R.A. Chaudhary, another senior counsel, assisted by Mr. A. Mahmood for the petitioner. The petitioner is aggrieved with the settlement of the, settlement already done,
Yes, my lord.
settlement of the Barali Mari Gadwa via Barbari Tachari Gaon Niz Saharia ferry service with the respondent number
5.
5. For how many years?
2 years, my lord.
For a period of 2 years.
Yeah, to March 2026.
Pursuant to the NIT dated 8/2/2024. Yes, sir. The petitioner's case is that the respondent number 5 had submitted his bid for the Barali Mari Gadwa via Barbari Kachari Gaon Nis Saharia ferry service and the Jerry Mari Kachashila via Serang ferry service. Page 66 and one is at page 62. One is at clause 13, one is at clause 4. Okay. Yes, sir. The petitioner, the respondent number 5 had submitted the highest bid for both the ferry services. Yes, sir. However, the petitioner had withdrawn his tender for the Jerry Murray Kashtaria via Serang ferry service, due to which his earnest money deposit bracket EMD was forfeited and he was prohibited from, and this point number 3 was prohibited from, prohibited from submitting any tender in IWT. What is IWT?
Inland water transport.
In inland water transport, bracket IWT,
Lordship,
for a continuous period of 4 years. That is for the calendar years 2024, 2025, 2026, and 2027. As per clause 16 of the NIT. Next para. The petitioner's counsel submits that once the petitioner, once the respondent number 5 has been debarred from from participating in any future tender, the petitioner, the respondent number 5 could not have been settled with the Barali Mari Gadwa via Barbari Nis Saharia. Very simple.
Other grounds is no objection from co-partners.
Huh?
Other ground is no objection not taken from the co-partner
For the land.
for the land.
Full stop. Next para. The counsel for the petitioner further submits that. But that is the further submit that the respondent number 5 did not take no objection certificate from the other co-partners of the land in question, which had been submitted. Full stop. Next para. Issue notice returnable in
Well, Tributary is also present matter. You can-
3 weeks. 3 weeks. Miss MD Bora accepts notice on behalf of
1 to 4,
1 to 4.
1 to 3, 4,
1 to 4.
1 to 3, yes,
1 to
4.
4. So she submits that clause 16 of the NIT does not bar the settlement of that number 4, clause 4, with the respondent number 5, in as much as clause 16 only debars the respondent number 5 from participating in any future tender. In the present case, the petitioner had participated in the tender notice dated 8/2/2024 for both the
Very services.
ferry services as indicated above, and the withdrawal of the petition, the withdrawal of the respondent number 5 from one of the tenders could not bar the petitioner from being considered for the other ferry service. Next para, Mr.
Yes, sir.
S.
Ali.
Ali, learned counsel for the caveator, respondent number 5 submits that he has not received a copy of the writ petition tilting. Full stop. Next para, Mr. A. Mohammed shall furnish a copy of the writ petition to Mr. S. Ali within the course of the day. List the matter.
So service complete, madam.
List the matter on, list the matter on 20th January. The respondent shall file their affidavit in the meantime.
Extra copies may be served to us also.
Extra copies,
Madam.
Deep problem.
Order no steps, item 5.
I have taken step.
Yeah?
I have taken step, lordship.
when?
Lordship, on lordship. 13th of this month, lordship. I
13th.
mistaken- Mr.
Mr.
B. Gogoi appear, lordship.
What is your name?
B. Malakar, lordship.
Mr. B. Malaka, learned counsel for the petitioner submits that steps for service of notice upon the respondents number 2 and 2 to 4 have been taken on 13/12/2020. Miss
H. Barwa,
A.
H. Barwa,
H. Barwa appears for
P. Nayak,
P. Nayak,
for PW.
learned counsel for the PW.
1, 2, 3, 4, and all the respondents, lordship.
This is the matter after 4 weeks.
Please bring your party item 6.
Lordship, the irrigation department chief engineer and executive engineer, they are no longer in office. What we have included the response number 4 and 5 also.
Mr. S. K. Das, learned counsel for the applicant, submits that Fazal Mohammed Chidiki, Chief Engineer, Irrigation Department, Government of Assam, Chalmari, Guwahati 3, and which one?
Ashwin Kumar Bora.
Achut Kumar Bora, Executive Engineer. See, huh? Names are here. Should be included as response number 4 and 5.
4 and 5.
Prayers allowed. Applicant to submit a corrected copy of the cost title to the registry. The I is accordingly allowed and disposed of. Huh? Then you write. In the main case, in view of the order dated 16/12/2024, passed in IAC 3820 of 2024. So are implemented as respondent number 4 and 5. Issue notice to the newly implemented respondents number 4 and 5. Petitioner to take steps for service of notice upon the respondents number 4 and 5 by receipt proceeding within 3 days. List the matter after 4 weeks.
7.
Same order. Lord.
Same order.
Okay.
Item 8 for admin.
This matter, a similar batch of writ petitions, your lordship, were disposed of, your lordship. So I'd like to place that order, your lordship. I didn't get the copy yesterday.
Huh?
I didn't get the copy of the order yesterday. I'll give it to your lordship.
We'll get it. We'll print it out.
78-page order, your lordship.
Yeah.
78-page order.
Okay. Where is the? What is this?
They're challenging this notification is 6/3/2017, your lordship.
It's the issue of.
It's the issue of 2000.
Okay, that 6/3/2017
Yes.
has been challenged. Just Meghanko, you print out the last few. Which para is it?
It's
From page number-
3140 of 2017, the last para, your lordship.
Yes.
Of 2017.
Just print it out. Oh. When was it passed? Yesterday.
No, lordship, it was passed in 27/9/2019.
And this case has been.
It's been pending since 2019. It's again now. Last para, 27, para 27/28.
Okay, right. No one appears for the petitioner. Mr. R.R. Gogoi appears for the Forest Department. The notification dated 6/3/2017 issued by the Principal Secretary to the Government of Assam, Environment and Forest Department is has been put under challenge. By the said notification dated 6/3/2017, the Forest Department has enhanced the levy, has enhanced the levy for transportation of timber, non-timber forest produce and minor minerals entering Assam through interstate boundaries. First up. Next para, Mr. R.R. Gogoi, the learned counsel for the Forest Department submits that the challenge made to the notification dated 6/3/2017 has been laid to rest by the judgment and order dated
Judgment or 27/9/2019.
27/9/2019, passed in
WPC number
WPC number
3140/2017.
3140/2017. So what has happened? Nothing has been done.
Most probably
Absolutely.
something has been done because after this order, no new petition can be filed, your lordship, challenging anything, your lordship.
No, but basically this order has now been put on hold.
Put on hold, your lordship.
So it carries on hold.
It's holding on, your lordship. There's nothing has been moved forward.
Whatever I said. However, wherein this court had directed that the impugned notification dated 6/3/2017 should be looked into afresh by the government of Assam in the Environment and Forest Department, keeping in mind the legal and constitutional requirements as well as the views expressed by the departmental authorities. Full stop. A decision was thereafter to be taken, and in the meantime, the restraint orders passed by this court on the impugned notification dated 6/3/2017 would hold the fee. Full stop. Next para. Mr. R.R. Gogoi submits that as on date, there is no change to the order and the effect of. Now, there's no change with the effect of the order dated so and so passing WPC number says, correct? Next para. So next. Accordingly submit that the writ petition should be disposed of in line with the decision taken by this court in WPC number 7. Next para. Para 28 of the order dated so and so passes so and so. Takes as follows. Next para, you're right. In view of the decision taken by this court in para 28 of this writ petition is also disposed of accordingly. Obliged, Lord. Yes,
The petition become infectious when the petition has died.
petitioner has died. Mr.
Yeah, but
Mr. MDA Matlib.
yes,
Learned counsel for the petitioner submits that the writ petitioner has died and accordingly the writ petition has become infected.
obliged, sir.
The writ petition is accordingly dismissed as infected.
Matter is infectious, Lordship.
Huh?
Matter is infectious, Lordship.
Correct, okay, right. Miss
K. Malakar.
K. Malekar, learned counsel for the petitioner, submits that the writ petition has become infected. Mr. H. Gupta. CGC appears for the respondents. The writ petition is accordingly dismissed as infected.
In this matter, my lord, amicably we are trying,
Huh?
amicably we are trying to settle the issue. So lordship may remit back the matter, my lord. In fact, this honorable court earlier also directed to settle the issue, but the authority has not considered the order passed by this honorable. That your lordship will find at page 181.
Although we have not filed our affidavit at that stage. And the direction was that whether the authority can on a table, if both the parties sit and may, if they can decide, then decide.
So we
So
are,
after that, nothing, this logical conclusion has come up.
they
And
passed the order, my lord, page 185, without considering the order passed, as per the order passed by this honorable court.
ultimately,
Page
we
185.
rejected the contract in 2021 after 4-5 years.
In fact, my
What
lord,
purpose will serve you?
my lord, in fact, we
If we-
approached the learned general manager, my lord. They are also not in a position to continue with that work, your lord, because the value is that zone is, my lord, not having that sanction value also. So I am instructed that if this honorable court directs that, they are ready to settle whatever the matter.
No, we're not going to say that.
In fact,
You all,
we will see
it's,
page
it is between you two.
my lord, page 181.
No, you tell me, you have to be clear. Are you willing to settle or not settle?
I
That's
have
all.
not received any kind of instruction.
Then why don't you obtain instruction from your client, both of you?
Or your lordship may, one observation, my lord, pendency of this writ petition is not a bar to settle the issue.
No. That's not, that is always there. You
But my
take
lord,
it
because
up.
of that, my lord, because the.
No, you see, whether you are settling the issue, not settling the issue, I don't know. Only thing I want to know is whether you are, is there a chance for, if you are settling the issue, good. But I need, only one side is saying it. The other side is not saying anything.
In fact, your lordship, this honorable court in the same proceeding 181, your lordship will see
Page?
181, my lord, pass the order. And relevant page, your lordship will 183. Be that as it may, since the petitioner is willing to execute the work at the same price within the mutually agreeable in time frame, and also consider the fact that the early education work without cost escalation will be in the best interest of railway authority as well as the public at large. I deem it appropriate to direct the authority to sit across the table with the petitioner and take a decision in the matter, keeping in mind the public interest at large. This writ petition is therefore being disposed of with a direction upon the response to consider the offer made by petitioner and on its own merit. And if
You see, Mr. Counsel,
my lord,
that observation was made in June 2022.
thereafter they passed the order, my lord, without considering the.
Now you see, those are issues, we do not know. It is just an observation.
lord,
It has
My lord,
nothing to do with the merits
my
of
lord,
it.
what I have been instructed, my lord, because of the pending, because there is a stay order in this matter, and if your lordship observe that there is a pendency of this writ petition is not a bar, then it will be settled, my lord.
I don't know, I want from them, I want something.
My lord, that observation, if your lordship, because of
No,
that,
no,
my lord.
sorry, no observation.
My-
I am here only to decide, not to play the politics between you two, I don't know. So, yes, you take a decision. What are you trying to do? Let us dispose of this matter. It's a contract matter. It is for public interest. whether you all are going afresh, you are terminating the contract.
Now, now contract is gone. Now he is here only for the money.
My lord, because my lord,
So
contract,
if that is so, lordship, it's a contract, like he can approach the arbitrator also.
my lord, this case is
The
not,
money is the factor.
my lord, in fact, they have awarded fresh contract and that is also, my lord, not executed, my lord. Because the authority is not in position to continue. That, my lord, I will place before your lord.
No, so what do you want now?
My lord, because my lord, we already approached the railway authorities and we have been instructed to take that objection. That's why, my lord, I am before your lord.
No, nothing here.
Or your lordship may direct them to obtain
Yes,
instruction
yes,
whether, my lord,
lordship, I can get the instruction if there is any so in
my lord, we are trying, my lord. If it is resolved outside the court, my lord, it is. Because this is my third round of litigation, your lordship.
Maybe third or
During
fourth.
COVID
whatever.
period, my lord, during COVID period, because of that. And before, my lord, that, my lord,
Is there an arbitration clause?
every contract is generally done.
Show me. Don't say that there is. In every
No, no, in
every
the
contract, there is
we have
not, there is
not,
no arbitration clause.
my lord, this matter will not come because of the reason, my lord. They.
I will see that. Let that decision be mine.
My lord,
Not
because,
yours.
what I am something like before, my lord, expiry of the contract period, my lord, they terminated.
Yeah, that
Because
should be.
because, my lord.
No one.
That's what.
Usually that's how it happens. No one terminates it after the contract
And
is
this
complete.
honorable, as per the direction of this honorable court, my lord, the impugned order 185, my lord. Now, my lord, we are sitting at, my lord, we're trying to, my lord, resolve the issue, my lord. Because the work regarding boulders, my lord, it is not in a position to, my lord, execute that work, my lord. Because the amount involved in the present tender, the concern zone is not in a, my lord, that sanction instance. So that, my lord, that is the fact, my lord, because this work cannot be executed by the anyone, my lord. That's why the fresh tender was also, my lord, not executed here. Because the money was not sanctioned. My lord, your lordship, page 55 is the agreement, your lordship. It was in respect of, my lord, supply of boulders, your lordship.
Page 140. It starts from 139.
Settlement of disputes, yes, reconciliation of disputes.
My lord, that we are trying, my lord. Before going to arbitration, my lord.
Yeah, notify the name of the conciliators out to the contractor. Because the alternative dispute resolution is here.
My lord, this will not come, my lord.
When was the contract terminated?
My lord, it was terminated earlier, thereafter, my lord, it was extended, your
Lordship
lord.
may kindly say page number 176 of the termination notice is a page number 176.
I want the council. I want the termination order. Yes, 176.
Is this the termination notice?
Does it terminate the contract?
Yes.
Termination notice.
Okay, stands rescinded. Yes. Page 176.
Thereafter, my lord.
1/9/2021.
And last order, my lord, 185. despite the my lord observation given by my lord that nothing, only on the basis of earlier my lord. Because my lord, at that time, my lord, labor, they were not available. And the site which was allotted to us, my lord, 2 sites. My lord, may I, in respect of same work, my lord, this tender was also awarded and that is also terminated. So my lord, unless
Yes, I think I think this is enough.
my lord,
Yes, I think you can go to the arbitration.
I think, my lord, your lord, because only the issue is in respect of my lord, my lord, closure of that contract, my lord, because now the authorities, we approach the authorities, my lord, and because of the pendency, my lord, it's otherwise also, my lord, the contract which was awarded, my lord, it was not executable at all, your lordship. My lord, that is the fact, my lord. And that's why
Right, heard, Mister. This is item
14.
Mr. A. Goyal,
my lord.
learned counsel for the petitioner. Also heard Mr.
CKS Board.
C.K.S. Barwa, learned counsel for
All the respondents.
all the respondents. The petitioner's case is that he was awarded a contract by the NF railway authorities, which was required to be completed within July 2020. After extension period has been given for completion of the work. However, the contract was rescinded / terminated by the divisional railway manager NF Railway
Prior to that, my
while termination notice dated 1/9/2021.
we are also challenging, my lord, earnest for feature notice of for feature of earnest money, my lord. Page 177.
The earnest money and performance guarantee money that had been deposited by the petitioner were also forfeited
Not forfeited, my lord, yet to be, because there is a still this honorable court was pleased to.
Were forfeited as per the order issued by the NF Railway. Yes, ma'am. The petitioner had previously approached this court, no, previously approached this court by WPC 4421/2021, wherein he had put to challenge the notice dated 25/8/2021 issued by the NF Railway, as well as the termination order dated 1/9/2021, besides the forfeiture notice dated 2/9/21. This court, on considering the submission made by the petitioner's counsel, had disposed of WPC 4421/2021 by order dated 24/6/2022 by directing the authorities to sit across the table with the petitioner and take a decision with regard to the contract in question, keeping in mind the public interest in large, inasmuch as the petitioner was willing to execute the work at the same price and within a mutually agreeable time frame. Next paragraph.
Page 185, my lord. Thereafter, after he had part this order.
The next paragraph. In pursuance to the order dated 24/6/2022, passed in WPC 4421 of 2021. A meeting was held with the petitioner on 19/7/2022. After deliberating on the issues that were discussed, the respondents felt that no public interest would be served by reviving the terminated contract, who had already been given opportunities twice earlier and had failed to supply ballast, leading to serious safety implications for the running of trains. First up, the next paragraph, the the office of the divisional railway manager, bracket W, NF Railway, Tinsukia, thereafter wrote a letter dated 18/8/2022 to the petitioner stating that the termination of the contract remained valid and that the security deposit would be forfeited as per the contract agreement. Next paragraph. The petitioner's counsel submits that what do you submit?
My submission is this order that which is impugned before this honorable court, my lord. This honorable court directed, my lord, observation to decide the issue at public, the authorities, my lord, decided whatever done earlier during the COVID period, no phrase, my lord, no consideration, and nothing has been taken into consideration, my lord.
Then what else?
My lord, to my submission before your lordship, because the work in question, it is not executable at all, my lord. In fact, the fresh tender was given, and that was also not executed.
Okay,
Because-
so it's not executable. Okay.
Executable.
So then, if it's not executable, then why you
That's why-
asking to
that's why, my
execute the
lord,
work?
if it is for- my lord, my lord, if it is closed, my lord, the award, then the question of my forfeiture will not come. If the authorities are not in a position to execute that work, that may be, my lord,
If it is not executable,
My-
then what are you praying for?
my lord, because my bank guarantee, my lord, they are going to
Okay,
forfeiture.
anyway, right. The petitioner's counsel submits that the
Subsequent tender was also,
impugned letter dated 18/8/2022 has not been made in terms of the direction passed by this court in WPC 4421/2021, wherein the parties were to sit across the table and take a decision eh, keeping in mind the public interest at large, as the petitioner was willing to execute the work at the same price and within a mutually agreeable time frame. Next paragraph. Mr. A. Goyal, the learned counsel for the petitioner submits that after termination of the agreement of the contract with the petitioner, the contract had been awarded to a third party. Which contract was also terminated subsequently. He submits that the contract is not executable. Is not executable. That's all.
my lord, to not execute, the reason which we have cited of the, so far as, my lord, delay of execution at that time.
Is not executable. Full stop. That's all. Next one. Yes, what have you got to say?
Lordship have taken care of the fact that we have already given two extension before. And it was, yes, it was basically during the period of COVID-19, and some of the labor perhaps were fall sick that time. But others,
In fact-
his competitors, they have performed their work
No,
very
my lord.
nicely.
It's-
His case is there, but see, from our side, only 4% of total 100 of the total work has been completed. Rest not.
My lord, wrong
Only
submission, my lord.
4% work.
Only 4%.
No, my
as far
lord,
as
where
it
it
is.
is there.
Next paragraph. Mr. C.K.S.
It is wrong submission, my lord.
Learned counsel for the C.K.S. Barwa, learned counsel for the
As per, yes, para 20.
learned counsel for the respondents, on the other hand, submits that the decision taken in the letter dated 18/8/2022 not to revive the contract with the petition has been taken after careful deliberation and keeping in mind the fact that the petitioner was a habitual defaulter who had already been given 2 opportunities to supply ballast. Correct?
Yes.
To supply ballast. He also submits that the petitioner had completed only 4% of the work. Where is that page?
That is, my lord, I am.
In our affidavit, Lordship, para number 20, as per supply, para number 20, that is page number 193.
We have given reply to that one.
As per supply schedule, so and so the petitioner supplied only 1958 kg of ballast from April 21 to August 21, which is 4%, 4.6% progress against the target supply during the period. Accordingly, Lordship, issuance of
Good
7
stuff.
days notice of the
What have I
to
said?
him. Then again, that.
So his work was supply of ballast only. or-
Ballast, yes, ballast.
Okay, what have I said? 4% of the work, as provided in, as stated in para 20
And 22.
and 22 of the affidavit in a position filed by the respondents number 1 to 6. The the counsel for the learned CGC further submits that as there is a arbitration clause. The petitioner can avail of the arbitration clause provided in the contract agreement for redressal of his grievance. Next part. I have heard the learned counsel for the parties. Page 185. The letter dated 18/8/2022 issued by the Office of the Divisional Railway Manager bracket W, NF Railway Tinsukia. In compliance with the order dated 24/6/22, passed in WPC number 4421 of 2021, states as follows. Page 186 from here to here. Okay, next paragraph. Para 20 and 22. For the affidavit opposition filed by the respondents number 1 to 6 states that as per the supply schedule dated 12/4/2021, the petitioner had supplied only 1958 CUM of ballast from April 21 to August 21, which was 4.06% progress against the target of supply during this period.
That we are disputing, your lordship. That means.
This dispute, you say, at the beginning, after his submission, no, you write Mr. A. Goyal disputes the stand taken by the submission made by the counsel for the respondent that the petitioner had supplied only 4.06% of ballast.
Page 171, it is there, your corporate page, 171, your lordship mechanics.
And the
Okay.
same is clear from the letter dated
23/8/2021.
23/8/21 issued by the Assistant Divisional Engineer, NF Railway, Simalu Guri. What does it say?
It says, my lord, we have already started working and hence it is, we have been requested to supply ballast at Namru Ballast Depot also at the earliest.
Nothing says,
My lord, but
nothing.
my lord, it was said on 23 and notice was given on 25, my lord. after only 2
Maybe,
days.
but what is the,
My lord, otherwise, my lord.
okay, you cut that part, huh? Just last, just say that Mr. Goyal, however, submits that the submission made by the counsel for the respondent is wrong. That's all. That's all. Your letter doesn't say anything. Next paragraph. What have I said? Next paragraph. The denial of the said figure by the counsel for the petitioner clearly shows that there are disputed questions of fact. Clause, where is that, that again, that arbitration, that. Huh? Arbitration clause? Which page? Is 80.
Page 140, my lord. Clause 64, my lord. Page 140.
64 is 3. Appointment of arbitrator. Point number.
demand of
Yes,
arbitration.
page number 140.
Clause 63,
64 within bracket 3,
clause 64,
within bracket 3,
bracket 3
appointment of arbiter.
provides for. Just say clause 64, just say that. Clause 64
Because
provides
so
for.
many conditions.
Clause 64 of the contract agreement provides for settlement of disputes by way of arbitration. Under the Arbitration and Conciliation Act, 1996. So stop. Next one. In view of there being an arbitration clause for settlement of dispute between the parties, this fourth is of the view that the grievance of the parties, that the respondent, that the parties would have to, that the petitioner would have to approach, would have to avail of the arbitration clause for settlement of this dispute. Accordingly,
Disposed of, my- disposed of.
accordingly, this writ petition is disposed of with liberty being given to the petitioner to avail of the arbitration clause for redressal of his grievance.
No surplus.
Eight, please, the lordship matter pertaining to my lord non-payment of contractual bills, madam.
Yes, madam,
Lordship, here the deputy commissioner is a competent authority to make the payments.
so,
Yes, sir.
The deputy commissioner is the party here, madam.
okay.
My name is Page number 18, my lord. Bills were prepared in the year 2017 itself, madam.
But no affidavit.
Right.
This also you have, last time it was listed on April. You should have to pursue. Yes,
I don't make any reflect our name, otherwise we have missed the file also.
okay.
Madam, last
In our
quarter,
name,
my
we have
deputy.
rejected.
Miss D Jane appearing for
Respondent number 1, 2, and 3.
1, 2, and 3, comma, Mr. K Gogoi for
This one of 5.
respondent number 5,
Four.
4, and anybody else?
No, Lord, 4, only 4.
And shall obtain instructions and file their affidavit within 4 weeks.
Yes.
Registry to reflect the
Yes.
name of
Yeah, some.
JSM in the cause list. List the matter. Leave it.
Apply, sir.
Item 16.
Lordship, we have filed affidavit lordship. Against the affidavit, my friend has filed reply lordship. So contradiction is there here, record is necessary. So lordship may give some time, I will polish the original record, then lordship will be easier for my lord to decide the issue.
Okay. Mr. K Gogoi submits that he will produce the records on the next day.
Lordship.
Accordingly, list the matter on,
After 2 weeks or 3 weeks, lordship. After.
list the matter after the vacation.
Lordship. Any day.
Obliged.
17.
Lordship, pending contractual bill, respondents have admitted the amount, Lordship. They have filed affidavit in opposition.
Okay.
Page 30 of their.
My lord may, on the basis of page 30, my lord may dispose of the matter. Otherwise.
How much is the admitted amount?
Admitted amount, lordship, it is, he has claimed originally lordship 65 lakhs, 1,877. Out of that lordship, 2,97,037 rupees was paid lordship. Remaining amount is 62 lakhs, 40840 lordship.
62 lakhs?
4,000.
4,840. And 30 is lordship there, page 30 lordship.
Okay,
Page
right.
30.
Heard Mr.
P.K. Mishra.
D.K. Mishra, learned counsel for the petitioner. Also heard Mr. K Gogoi, learned counsel for
Respondent, so, lord.
all
Lordship.
the respondents. Mr. D.K. Mishra, the learned counsel for the petitioner, submits that the petitioner has been supplying hardware, electrical goods, BASA materials, miscellaneous goods, computer items, stationery items, etc. to the office of the Commissioner of Police Guwahati. However, the bills raised by the petitioner for the period from May 2022 to August 2023 amounting to rupees 65,02,618 has not been paid to the petitioner. Next para. Mr. K. Gogoi, learned counsel for the respondent, submits that out of the rupees 65,01,
Lordship,
877.
Lordship, admitted amount is Lordship 65,01,877. He has excess claim of 741.
Acha.
Page 30.
What have I said? $65, acha. Wait,
Yes.
wait, huh?
Page 30.
Submit that though the petitioner has claimed
Lordship, Lordship.
rupees 65,02,618, the actual amount, the correct amount payable to the petitioner was rupees 65,01,877.
Lordship, Lordship.
Full stop. Rupees 2,97,037 having already been paid to the petitioner.
Lordship.
The petitioner is still to receive an amount, the balance amount of rupees 62,04,840. Full stop. He submits that in this regard, the respondents have submitted various bills. What is this? Proposals.
Proposals,
Have
sir.
submitted 38 proposals to the sanctioning authority for the sanction, for the sanction and approval, sanction and allotment of funds,
Lordship.
allotments of funds. He submits that as and when the sanctions are made and proposed and the funds are allotted, the outstanding dues of the petitioner would be paid.
Lordship.
Next, I have heard the learned counsels for the parties. Para, T bracket A. No, this is para 3 bracket, para 3, this is para 3 of the affidavit of position filed by the respondent number 3 has given the list of 38 proposals sent by the office of the Commissioner of Police Guwahati to the sanctioning authority for approval and allotment of funds for payment of the same to the petitioner. The details of the proposals as given in para 3 of the affidavit of the respondent number 3 are as follows. Page 30, 31, 32. Huh? In view of the fact that the respondents have admitted their liability to the tune of rupees 62,04,840, the respondents are directed to sanction the proposals and allot funds for making payment of the admitted amount to the petitioner. So the entire exercise should be concluded within a period of
4 months. Lordship.
Huh?
4 months. 3 months. 4 months.
4 months from the date of receipt of a certified copy. The writ petitions are
Fixed to item 47.
Lordship, I have provided the copy of the edition.
We have received it.
Okay. Now, so,
Lordship. Kumar Das and Ashish Das both are one and same person.
One same.
Lordship.
yes, so madam, this page 47, 46A.
Yes, Your Lordship.
So his name is there, D.
Yes, yes,
Is
Your
it-
Lordship, yes. D has been marked. I don't know where is this here, but I saw in the English version.
So we'll ask the SP Boda Dubri to
Make a reference. Your
make a
Lordship.
reference to the tribunal.
Yes, Your Lordship.
Okay.
Yes, Your Lordship.
Heard, Mr.
A. Thakuria.
A. Thakuria,
Yes, Lordship.
learned counsel for the petitioner.
Lordship.
Also heard Miss
P. Barua, Your Lordship.
P. Barwa for the election
Commission.
commission. So Mr. S.R. Barwa appears for
For response number 5.
5. What about 7?
For the separate, that FT councils are there.
7 is SP Boda.
Yes, yes. They.
Who are they? I need them.
J5.
Yeah, J. Fine.
Whether.
Maybe, I don't know. They are marked here, but they're copied. And I think in our case, it's respondent 3 and 4 has been, it's both election commission of Assam is also there.
So you're for?
Election commission of India, you know.
You're for Election Commission of India.
Yes. Yes.
Who is for the others?
J5.
Mr. J. Payang appears for phone number.
They appeared for response number 2. 2 and 7.
27. D voter. Okay, that's the same order. D voter.
40.
Obliged. Your Lordship.
Are you okay?
40?
May it please your lordship. Lordship, the petitioner, president, secretary of a market management committee, Saturday weekly market, lordship. By dint of an agreement, they are running a weekly market, lordship. Agreement is at page 7, lordship. Page 31, lordship. And XRG, lordship.
Yeah.
So there is specific in the agreement that the agreement.
Who are you? Who are you? You are the
President and secretary of market management committee, Saturday weekly market, lordship.
Can it be after some time with the PNRE council, he told me.
after some time.
Lordship.
Next.
I think maybe.
Hello, record has been called for, record is received, I am told. Hello, dear, first,
Item 18.
19.
So what are you from? 19. Okay, item 19 is
18 or 19? May be losses. The loss will find on page 17. First, there was a tender for transportation of PDS rice to under NFSA Act to different areas of the Dhuri district. That was a page 17, matter on 3/8/2024. In that matter, there is no condition for priority to the charge area experience. There was no such condition there. Charge area experience was not there. Priority to charge area experience certificate. Suddenly that was cancelled matter on 2/9/2024.
this tender notice was cancelled.
Cancelled without any reason, without recurring reason. And
Anyway, that's not under challenge, huh?
no, that is not. Okay.
Then
Anyway, I am just trying that. Then the clause manner, the charge area development certificate. In 2/9/24 manner, page 21, there has been a one line that priority would be given to, should be given to the charge area certificate holders. Charge area expense.
there is a subsequent tender notice, you mean?
Yes.
Where, which page?
Page 21. He says, this clause has come into play, my lord, in subsequent notification, tender, otherwise it was not there earlier.
Where is that charge area?
My lord, sure, my lord. Page 21, page 18. Yes, page 22, my lord, sorry.
Okay, NIT dash 3/9/2024.
Clause 21,
Yes. That is at page 23, my lord.
23.
There I am coming. Before that, my lord, you will also kindly mark condition number 10 and 14. 10 and 14. That's what I am on. Then my lord, kindly come to condition number 21 and 24. On this, yes, this is my lord. On these 4 points. In clause 21, page 23, my lord, the bidder should have experience in transportation of rice on the soil in tier 1, tier and tier 2 system. Experience certificate shall be obtained from the DC, so and so is required and to be uploaded. Varieties should be given to the state bidders and having adequate knowledge of entire area. It was subsequently inserted, my lord, in the
What do you mean by char area?
so I mean this riverine area. Riverine area. But the entire Dhuri is not riverine, because there are number 6 or 7 major towns. It is not third area. And in Bilasipara, my lord, one assembly council, there is some third area. There, my lord, my tender was cancelled. Now I'll come to the point, my lord. Allegedly on 4 counts. On 10, 14, 21, 24 clauses. Technically bid was cancelled.
Okay, yeah.
That first was that the amount of 25 lakhs, their allegation is not credited in the name of the deputy district commissioner Dhubri. Against that, by this affidavit, we filed the document, bank certifying that it was credited to the district commissioner Dhubri. That in the affidavit annexure M is there.
No, first of all, where is the rejection of your,
Yes,
where is which page is it?
this one, just I'm coming. 30.
30?
30.
30.
I am serial number 3, Vivek Transport Agency. These are the grounds given for my rejection. Yes. In paragraph 9, we have replied now. Petition. The tender paper be it submitted, uploaded by Vivek Transport Agency, was placed before the tender committee for scrutiny. After careful examination of all the documents uploaded by the bidder, it is found that the bidder is class 4 registered contractor of road construction department, where the bidder has submitted the tender for rupees 5,000 online mode instead of demand draft mode. Because while filling up the form, there is a clause in the bank that you have to pay online. Otherwise, the form would not be paid in. That we have explained. Online mode is the actual term and condition. Again,
So again, the 25 lakhs, you made it in favor of yourself,
no,
in favor of himself.
that is
Is it?
that the election. That is not true. You will also have annexer M to the affidavit and while I will separate sheet also.
Why is it not part of the affidavit?
Yes, everything we have annexer.
Which page?
Lordship says annexer M.
Page 59.
Yes, page 59 annexer M. That is subsequently matter.
Which one?
Page 59.
Page 59 is a subsequent document.
Subsequently, after that, not regulation of the bid. In whose account it was, the question was in whose account it was deposited. It is certified that Vivek Transport Agency is having plans. Lordship may see the wording of that letter. In our plan, which was issued on 23/8/2024. Further, as per our party report, the same TPR was.
23/8/2024. It was issued.
The technical evaluation was opened on 16/9/2024.
Just a minute.
This letter is 1910, and Lordship will may mark this letter further as per parties request.
Just a minute. Just a minute.
Because they didn't believe it.
Technical evaluation
on 16/9.
But date is given
was issued on 23/8/2024. This certificate I asked subsequently because they didn't believe it. That's why. Let the record say they have not received this money in the DC's account.
No, you see,
Brother, please sit down.
can you show me your, can you show me the photocopy of your earnest money deposit? How did you deposit?
Yes, yes.
Where is that?
Just I will read that up there. Just, just stand slowly.
That's what, I want to see that.
Vivek Transport, it would have been made in the favor of the district commissioner.
It is there, Malu. The one, just finding out. Yes, my lord. 28.
Huh?
Page 28.
Page 28 of your writ petition.
Yes.
Page
Because there
28.
is no such column here, so the bank authority has received. Yeah. Village to District Commissioner Dhubri on the top. Yeah,
Yeah.
Henry,
yes.
No, place to district. This is did by hand.
Hello? Yes, by the bank. There is no column as such.
There's no
That's why I see the column of deposit slip.
Okay, they're saying that this page 28.
Yes.
This is the one that has been pledged to the district commissioner. Is it correct?
Yes.
Huh?
No,
Yes. If it's yes, then it is
No, no.
correct.
They said, we are saying that it should be made not by handwritten lordship.
Correct.
In that prescribed format lordship, it should be
Correct.
made in favor of district commissioner.
Correct.
But it is not found available lordship. And the above handwritten, they have placed.
Uh-huh.
It is not.
Otherwise, show me how others have submitted.
Yes.
Other bidders.
Mine is Bank of Baroda.
Maybe.
This was the part of the matter.
You see, banks don't submit like this. It's not by hand. They don't.
What is there is no such column. Money was deposited, no doubt. Let them say they have not received the money in their account. And in paragraph by day of the account amount, they have not denied. They have not received the money. In the deputy commissioner counter, Maro. Paragraph 8. That with regard to soon.
How can it be received from? This is received. What? What? You mean this one?
Yes.
What do you mean above? That mega plaza? What are you trying to say? I don't understand what you're trying to say at all. Not making sense. in the shape of a fixed deposit. It should be in the shape of a fixed deposit. Is this a fixed deposit? This is not a fixed deposit, is it?
No, madam. This is, the earnest money matter, 25.
Deposit amount, what is this? Who is for the Bank of Baroda? Any counsel here?
So there will be stand that thing, right?
We'll call the officer.
I'll find it out.
Yeah, let him call, we'll see.
All banks have standing coffee.
This cannot be a fixed deposit. This is not a fixed deposit.
No, not.
Then, if you're fixed,
It is the earnest money matter to be deposited.
no, but it says here,
Yes.
this earnest money only to be 25 lakhs only to be deposited in the shape of fixed deposit. It has to be deposited in the shape of a fixed deposit. And out here, it is in your name. It is not in the name of the
It is
thing.
placed to the deputy commissioner matter,
Huh?
deputy commissioner, it is placed. Clear, madam.
I doubt. I don't think this is correct. You see, the name of the depositor will not show. Now it is I mean, to the person who it's supposed to be deposited, that person's name will show. You're depositing it in your name. How can it be?
No, my lord, otherwise.
Clause 10 is the condition, my lord.
Correct,
Yes.
page 22.
Yes, absolutely correct.
Deposited by Vivek Transfer Agency, madam. Placed to
No, we'll ask the Bank of Baroda to give a certificate. That'll clear everything.
the matter, madam, whether the deputy commissioner is received or not.
No, that is not the issue. The issue is when a fixed deposit has to be made in the name of the deputy commissioner. Whether the certificate that you have attached to your writ petition is a fixed deposit made in the name of the deputy commissioner. I've never seen, I've also made
Yes.
fixed deposit since a long time. I've never seen a bank write my name in by pen. It's all computerized. It's all there. Cannot be. I don't believe this at all.
Yes, madam, it is fixed deposit. You also kindly come to.
No, who has signed this? Deputy Commissioner, so, no signature, no seal. Who?
Bank employee signed, and you will also kindly come to this the column number. Tenure deposit.
Okay, that is one case. Then what else? Besides this, then what
Tenure
else?
deposit is 399 days.
Maybe.
390 days is fixed deposit or term deposit.
You see, the thing is that the name out here in the fixed deposit is not in the name of the deputy commissioner. It's in your own name. You are making a
No,
fixed
here
deposit in your name.
It's not in my name. The depositor, I am the depositor.
Okay, let's go to the next point now. That point you have already said.
Now, my lord, that earnest money of 25 lakhs, that is the issue here now. The original solvency certificate of the petitioner not found. The evidence is submitted, not found. It is submitted. It is submitted, it must be record, but they say it is not found. No SAR area development experience, they try to enter SAR area, I have experience of transportation of religious rights in other places. Enter Dhopri is not SAR area. Here. Now, my lord, we replied that, my lord, subsequently, annexarium I have shown your lordship's my that it's an affidavit. The bank is certified that it was in the deputy commissioner's account. The original solvency certificate was submitted. The third area is not mandatory.
So they have said that solvency certificate not found.
Not found.
Then?
But you submitted
Huh?
not in original,
Acha, not found in original, not found in original.
but they have said not found. So,
They have said not found,
they have said no, not found.
they have said not found in original. You see, it says
But they have
in
received-
original,
they have received it. When
but
they-
not in
they
original.
have received it.
So what? It's like saying
Now,
I need, you have to give rupees 10 lakhs. Instead of giving real money, you're giving monopoly money. They want real money.
Lordship may see the 101 there, the rejection that order, your comparative statement, Lordship will find it page 101, my lord. The remarks for 119. He's the third bidder, my lord.
Third bidder.
Yes.
That means FDR. No, what is it? Page 101?
101 page, it's written that few documents that there are 5 rejection, my lord, grounds.
Hmm.
That is there, my lord.
but they have five only here, in the committee report, it is 4 only. Now they have got 5.
Few bid are found in Hindi, not in English. Okay. ठीक है. What else?
Then, in the case of respondent A, the, on which favor.
Who is respondent number 8? Karen Mahanta.
Because of respondent 5. Solvency certificate submitted from ICICI Bank. That is not tenable because it should be from the nationalized bank, not by private bank. But that was accepted by them. Then private bank, next is nationalized bank. Clause 24. Then, my lord, in clause 14, instead of goods transportation vehicles. Yes, submitted, my lord. Dumpers,
Just a minute. From any nationalized bank.
yes.
So,
Clause 24. Condition number 24.
just a minute. Okay, first is not by nationalized bank. Number 2,
Number 2 is, my lord, that here instead of submitting the transportation boards, goods transport, he submitted the passenger carrying boards.
where is that?
There is a clause 14. Condition number 14 of the tender.
Clause 14.
Page 52, my lord.
Which clause? 14.
14.
Yes, it has to be submitted by. So what is the problem here in clause 14?
Clause 14, my lord. Here, my lord, passenger carrying board, carrying goods.
Huh?
Right,
Huh?
because it is clearly said in the, my lord, clause 14 that it should be goods transportation vehicles.
Huh?
Goods transportation vehicles.
No.
And boat
Sufficient
also.
number of vehicles.
Huh?
Lordship will see that there.
But I don't understand what this
Clause
says.
14, it's written sufficient number of vehicles. It's
Ah.
not written goods vehicle or something like that.
Anyway,
Will mark that.
anyway. If we.
Sufficient number of
Yes.
vehicles.
Vehicles.
Sufficient number of vehicles are written. So what? So he does not have goods vehicles or what?
No. That is what he has submitted in his tender.
There's not written goods has
He
not.
has
been
submitted
written in
dumper and passenger boards. If my tender is defective, equally his tender is also defective, my lord. There should be then retender.
Must have sufficient number of vehicles.
Yes.
That is,
including engine boat. So he has vehicles or not?
He has no vehicle. He has only dumpers matter to carry the soil and
So dumpers are good enough.
boulders.
So
And boat is goods carrying boats. Because certainly your lots of.
so he doesn't have good carrying boats.
No. Doesn't say good carrying.
Huh?
No.
Yeah, I'll hear you anyway. So it does not have goods, vehicles
Yes.
and good carrying boats. Anything else?
Now I will kindly see. With fitness certificate, bidder should submit board. And he has submitted 5 number.
Which page are you reading, Mr. Council? You are reading
Reading clause 14.
clause 14.
Yes.
Yes. Of
The
page
vehicle,
22.
Vehicle made for transportation of allocated food grains. Mean transportation allocated food grains under NSO must take the facilities of GPS with shall be monitored from the control room. The bidder must arrange a sufficient number of vehicles, including engine board, for ensuring time-bound lifting and distribution of allotted food grains, both in tier 1 and tier 2, as per time schedule fixed by SOP. To ensure the bidder should be submitted both RC up to intercensor to goods carrying vehicles. Now, my lord, in my additional affidavit, I have annexed. Now, my lord, there is a post tender. Tender finalized, he was a loan tender ultimately. The technical bids of everyone was rejected except this response file. And the rates were negotiated post the tender process over. I managed that in my ADCIBDB. Rates were negotiated after the settlement of the. You'll also kindly come to page 55 of the my ADCIBDB.
Page?
55. Rates are being negotiated between C and this person. And Sir J. This is into the with reference to the subject cited above, I am to inform that the average rate quoted by you both in tier 1, tier 2 is 148.91 per quintal for transportation food grains under an episode 13 of the financial year 2014 24-25. In respect of 37 number 20 is much higher than government approved rate of transportation of food grains under so. In this connection, you are hereby informed that the approved government rate for transportation food grains under so per quintal is 150 per quintal for this hills, riverine, difficult areas. This is the rate quoted by you is not acceptable. However, you may carry transportation to food grains both tier.
Okay, so what are you trying to say? I've read it. So what do you want to say?
Standard, my lord.
Huh?
Post standard, he is quoted 148 rupees 91 paisa per quintal.
And they are asking that
He should the area is 150 per quintal. 1 rupee 9 paisa. It was negotiated. Then again, second letter by DC to that respondent 5. Again, that again reduced to 142 from 143.
Next letter, next real page 57. So can it be done, my lord?
I don't know, you have to tell me. You cannot put questions to me. You have got to teach me whether it's correct or not. You're the one who has to tell me. Incorrect. Why?
Why, but in almost similar case, my lord, it was so happen in BCCL case also. This letter is judgment was Supreme Court.
Hmm.
They both were cancelled and they were asked to be retendered. I'm giving the copy of the judgment. There are 12, 13, 16, and 21. 21 is the power of the court.
Yes, which paragraph?
You also will start first from paragraph 11.
Look, we cannot have the entire thing reading. Please let us.
This is what we expect from your lawsuit, madam.
You are going to take the whole day otherwise this way.
Madam,
You take the entire day. A whole bunch of your friends are there behind you waiting for their cases.
madam, I had seen in my life one case going only on the word interpretation of one word decision.
Ah,
7 days argument.
no, those are for that case. This is a case of contract where this is a case of food grains. The poor people can't wait for 7 days. They need to eat every day. Morning to night they need to have. Even if you, I am quite sure you cannot
But
stay hungry for 2 days also.
Paragraph 21 has said.
So we
madam,
cannot
that
wait.
If it is arbitrary and madam, not in terms of the,
Just show me where it says that there cannot be negotiation of rates.
yes. Post the negotiation is not permittable in my
Yes.
section. It is up to your
Where
lordship.
is that?
You will also kindly start the condition here was violation of clause 10 of the tender. So, my lord, please, paragraph 13. Then you will also go to, I'm just start cutting the matter. Paragraph 16. Ultimately, both the cases were terminated and it was retendered. Paragraph 16.
Where is that? Where is the word? Where is that word negotiation in this judgment?
Will also kindly come to paragraph 16.
16, yes.
Judgment the respondent date had not submitted scanned copies of his audited annual report for the last 3 financial years. At the time of submitting, uploading the previous document.
Audited
the
report is different. Audited reports are different. Where is the question of
There are no scanned
negotiation?
copy. He submitted simply non-scanned copy.
It's a different thing, Mr. Counsel, submitting scan copy. You see, what you are trying to project and what is here is different. This has got nothing to do with it. This has got nothing to do with negotiation.
Yes, then my lord, ultimately, last paragraph, my lord, the process of tender was cancelled and retender.
Okay, maybe. But where's the word negotiation? I haven't found one word of that word negotiation is not here in that judgment. You are saying
Negotiation word is not there, but post tendering, here also submitted one document.
post tendering is different. That's a different issue.
Can complete it.
This is not a
Can it, my lord, new document we can be introduced?
Mr. Counsel, where is the new document here? This is a negotiation.
If he does not know the negotiation.
Negotiation is not a document. It's a negotiation.
Negotiation and single tender, my lord. Minimum, my lord, that clarification from the bank would be the lordship you have called.
That's all. Anything else?
Yes.
Okay. Right.
The record has come, my lord, record will be.
But first thing is that, my lord, my learned friend is saying about the negotiation, but this is pursuant to a government decision. Lordship may see page 99.
In government decision, arbitrary minors, so everything goes. How do I?
That is totally in greater interest of public service. The following decision has been made by law. I'm not. May I read, my lord?
Yes.
Yes. The additional deputy district commissioner and in charge deputy director so-and-so Dubri member secretary has explained the procedure of e-tendering and the purpose of calling this meeting of selection of the committee to finalize the financial evaluation as per financial bid summary. After examination, all relevant documents downloaded after financial bid opening, the only successful bidder of technical bid, that is Horen Mounto, has submitted total amount of 5,510 considering both tier one. and tier-
5,510 meaning lakhs or what?
No, no, this amount, 5,510.
Okay.
Considering the both the tier one and tier two respective of Dhubri subdivision and Bilasapura subdivision. After thorough evaluation of the BOQ uploaded in Haran Manta, it is found that average rate quoted per quintal is 148.91 considering 37 numbers of GPS so and so. BOQ total numbers of 38 segregating Gauripur town and Dhubri town as separate unit, but both are within Dhubri so and so. The rate quoted by Hashi Haran Manta is much higher than government approved rates for transportation of food grains so and so. 136 per quintal for plain areas and 150 per quintal hill, river and difficult areas as per point number 9 and 10 of the minutes of meeting dated 9/9/2013 of group of ministers constituted to study, implement the food security security ordinance 2013 and so and so. Received from the Commissioner Food and Civil Supply Distribution Consumer Affairs Legal Metrology Assam Ulubari so and so to refix the handling and transportation cost of lifting of PMGKAY rice under NFCA SA in tier one due to reproduction of distance of 10 numbers of GPS out of 37 numbers of GPS under route optimization. However, the tender committee, after considering all circumstances and in greater interest of public service, the following decision has been made. A letter should be issued to the bidder Shri Haran Mounto to submit willingness to quote the rate below 143 per quintal, which is average for both areas and hill, river and difficult area government approved rate of transportation food grains both tier one, tier two in respect of 37 numbers of GPSs for the financial year 2024-25 of the Dhubri district. And if acceptance is received from this, a bidder may be appointed handling and transport contractor for transportation of food grains under NFSA 2013 under tier one and tier two system in respect of Dhubri, Sadar subdivision and Bilasipara subdivision, Dhubri district for the financial year 2024 and 25 and asked to execute the agreement in non-judiciary stamp paper per prescribed format as per terms of condition of agreement. So this is a decision was the committee decision. This is and the negotiation took place and the rate was set. Now the next.
What was the ultimate rate fixed?
Ultimate rate is better 142 that is been there, my lord. Lordship may see that last. I need to put all the data. Lordship may come to page 57, my lord. 142.94, my lord. Quintal. This is the rate, my lord.
Where?
The Dhubri Sadar subdivision and Bilasapura subdivision 142.94 per quintal. That rate, my lord.
Which page? 140, page 57.
57. In the middle portion, my lord.
Yes. 142.
Yes. And lordship, my understood saying that page 59, the certificate which was given that my lord 25 lakh rupees, my lord.
Yes.
He is subsequently given this, my lord, 1910. Because 69 the technical bid was open, and he has given. This is certified that Messrs. Vivek Transport Agency is having TDR of 25 lakhs, TDR number so and so in our bank, which was issued on 23/8/24. Further, as per party request, the same TDR was placed. Now he subsequently done it, my lord. Previously, he has placed in favor of himself, my lord.
TDR will be?
TDR means, TDR will be term deposit receipt.
Term deposit receipt.
Receipt.
As per party request, the same TDR was pledged in the name of this.
So subsequently, my friend, it cannot be. And you know, my lordship knows that in commercial transaction, and when it's this type of tender, when public interest is involved, you cannot take it by chance that they say something and do something, my lord. And the clauses of the tender condition, my lord.
I think maybe we should call this make a chief manager party
Bank
and let him come here.
Yes, that
to clarify. And then if we find that it has been done in your name, we impose heavy costs on the petitioner. If we find that if it is found that the petitioner had made the fixed deposit in his name,
Because my lord.
The lordship may come to tender condition, my lord.
FD.
Huh?
In the tender committee clause also it is FD, but only that it was in my name. If it is in my name, then.
Okay, it was in your name.
No, then the money would not go to.
It was not in your name.
It is not, otherwise money would not go to DC.
Huh?
If it is in my name.
No,
let
no. You see, initially when you made this pledge,
Yes.
this TDR,
Yes.
in whose name was it made? We will
It
ask
was-
that.
it was-
Later on you changed it, that's a different thing.
No, I'm not on that, what you are also saying.
Anyway, we'll
I am on that matter that since it was made, placed in the name of the DC, if the money had not gone to the DC, if it has gone to me, then I am liable to be cost. Bear the cost.
No, no.
If it is deposited.
We'll see, we'll see. We'll see, we'll make him a party. I think I've heard
That
enough.
is my lord, whether DC has reached the money or not, that is the fact.
That is not the issue.
Whether it is,
You see, subsequently, if you may put it into his account or whatever, that's a different issue.
why should
What
they-
has happened in the initial stage?
No. It is technical bid document.
So we will see, we will see.
I'll place two judgments, my lord. If lordship permits.
You see, there are two ways. Either I can decide this matter, which I can, I know how, but or to clarify this issue of bank account, this fixed deposit, I make this bank a party. This court will order it. It will be implemented. And we issue that person to come and give a report with regard to this.
I think that can be done, my lord.
matter.
I'll put your lordship, my lord.
When we made the party. And call the report.
Hmm?
Call the report, call the bank,
Naturally.
yes, that will solve the problem.
Regarding the third area experience, but this mistake, side area. So we need to notice.
Char areas. Correct, that's there, many aspects.
That is not there. That is not.
They
there.
didn't have that.
Yeah.
Okay. Anyway.
When
Okay,
They said
right.
They are having it, but they are not having it. my lord.
So there is
Okay.
not a
Just
mandatory
give me
requirement
your
for
citation. I'll take a decision.
My lord.
Give me a citation.
Oh, next. My lord, first, my lord, I
Our
will,
area is not mandatory.
Central Coalfields Limited and other vessels, my lord, para 43, my lord.
What is your rate anyway? What is the rate that you quoted anyway?
I have quoted 148. Very high. Sorry,
Slightly less than him.
136.
No, mine is less, my lord, after negotiation, my lord.
No, before negotiation, how much?
Fisherman, how much?
He quoted 148.
148.
150.
Ah,
After
and
negotiation, I
your,
quoted
your,
136. Because the
you
rate was
quoted
already
136.
136.
You quoted less.
Yes.
that will come when he is successful in the technical bid. Because it is in the of the financial bid, when we open up the successful bid.
know.
Char area certificate was
Lordship,
just to favor him, I know there is only one because he was the only person who once transported goods in that area, in Dhubri district.
Lordship, may,
Others, then if they have the mandatory clause, then other, I would not even file my document, my tender. You know, there's a priority, not mandatory.
para 43, my lord.
There is quoted,
2007.
their judgment is
Yes.
quoted, my lord, in
Coalfields,
the judgment I have given also.
2016 86, my lord.
Yes, para 7.
43, my lord. Continuing in the vein of accepting the inherent authority of an employer to deviate from the terms and conditions of an NIT and reintroducing the privilege of participation principle and the level playing field concept. This court laid down emphasis on the
Central
process.
Coalfields, okay. Then,
Then, my lord,
That judgment is my,
the other one?
what is in the,
my lord, Jagdish Mandal case, my lord. This is para 22, my lord.
Okay. Right. Heard Mr. R.P. Sharma, Learned Senior Counsel for the petition. Assisted by Ms. R. Devi. Also heard Mr. J. Roy, Learned Senior Counsel for the respondent number 5. Assisted by Mr. P.K. Munir. Also heard Mr. S.R. Barwa for the respondents number 1 to 4. The petitioner's grievance is that his bid has been rejected on the ground that the same was not in conformity with clause 10, 14, 21 and 24 of the of the tender notice dated 3/9/2024. Now, of the terms and conditions of the tender notice dated 3/9/2024. Here and after referred to as the NIT. The case of the petitioner is that he had submitted his bid for selection and appointment of handling and transport contractor for transportation of food grains under NFSA 2013 for Dhubri district in pursuant to the NIT. Okay, okay, yes. However, the petitioner's technical bid was rejected on the
16
following grounds. 5 grounds, huh?
Yes.
It is a page 101. Okay. On the right hand side, huh? 5 grounds, 1, 2, 3, 4, 5.
Page 31, Lordship.
Huh?
Page 31 of our repetition. This is the minutes of the meeting. Lordship.
Acha.
This copy is from another.
Okay, don't use 101 then.
31.
Okay, you put 101, but use from 2 to 4, 2 to 5. Don't use 1. 1 you don't use.
There is some other additional
Add addition, that's right.
in this document, Lordship, the point. Sorry, yeah, experience.
Okay, you don't say that. It is here also. So we will not add 1, we'll add thing only. In terms of, continue, huh? No. What have I said this week? Was rejected by the Technical Bid Evaluation Committee as per its meeting minutes dated 16/9/2024. As reflected in para 3 of the meeting minutes, some of which is as follows, page 31, huh, number 3. Next para. So what is your, with regard to tender fee paid in online mode, you're not denying this,
Yes, Lordship, it is paid online mode because without paying.
but it was not paid in a demand draft.
Because once I have paid through online Lordship, there is no question of paying another 5,000 rupees for demand draft. And it is not known.
Okay,
how
right. The petitioner's counsel submits that once the petitioner has paid his tender fee in online mode, there is no requirement of paying the same again by way of a demand draft. Full stop. In respect of the second ground, for rejection of the petitioner's tender, that is, earnest money was not made in favor of the district commissioner, comma, the petitioner has relied upon the page 59 is 59. Has relied upon the certificate dated 19/10/2024 issued by the chief manager, Moria Lok branch, Bank of Baroda,
Also page,
which states as follows, page 59. Huh?
also page 28, Lordship. This is the
The petitioner's counsel also submits that the demand draft that had been made in terms of clause, the demand draft had been, submit that the fixed deposit the fixed deposit of rupees 25 lakhs, which had been made in favor of the district commissioner Dubri in terms of clause 10 of the terms and conditions of the NIT annexed as annexure D to the writ petition shows that the money had been, that shows that the fixed deposit had been made in favor of the district commissioner Dubri. She submits that the pledge, she submits that the same is shown by, the same is proved by the words, inverted commas, pledge to district commissioner, comma, Dubri, bracket, Assam, which is a handwritten pledge in the fixed deposit. She submits that though the name Vivek Transport Agency has been typed out in the fixed deposit, comma, the pledge made by way of a handwriting is the is proof that the same has been made in favor of the district commissioner Dubri. This is, I don't know, madam, we are really taking, you're insulting your own intelligence and mine also.
Lordship,
A bit too much, this is actually.
Lordship, this is not their case that they have not received this tender fee or earnest money. They have received it, Lordship.
Okay, so your case is that you have not made the deposit, fixed deposit in the name of the DC, but the money has been received by him. Is that your case?
But Lordship, certificate issued by the.
Huh?
Certificate issued by the Baroda, Lordship. It is issued in the name of district commissioner, Lordship.
That is afterwards. You have changed it. That's what it says.
On record, Lordship. It is a matter of record, Lordship.
Okay. If that is the case, you're taking the case, then I will see it. But be careful.
Lordship.
If I find out that you will have to pay in lakhs cost. Lakhs. Not half a lakh.
This is a matter of record, Lordship, since the Bank of Baroda itself certified it, that it is.
Well, we'll see. We'll see.
submitted in favor-
We'll see. I've heard you enough. No more. Next. Okay. Acha, with regard to solvency certificate,
It is also submitted in original, Lordship.
but okay, so the petitioner's counsel submits that though this technical bid evaluation committee had taken a stand that the original bank insolvency the original bank solvency certificate had not been found, comma. The petitioner had submitted the original bank solvency certificate along with its bid. she however submits that the petitioner does not have char area experience, correct?
Lordship, as per clause 21, Lordship, solar area experience certificate is not sought for Lordship. It simply says that priority should be given,
In any event,
Lordship,
clause
21.
21 of the terms and conditions of the NIT does not require the submission of char area experience
Certificate.
certificates. Huh. That's all.
Yes, sir.
Next para. The petitioners council further submits that the respondent number 8 has been selected. Five has been selected. Despite the respondent number 8 not having submitted a solvency certificate from a nationalized bank, as was required under clause 10 of the
24, my lord.
24 of the terms and conditions of the NIT. Further, a negotiation had taken place between the petitioner and the respondent number 5
After acceptance of financial.
after acceptance of the financial bid of the respondent number 5, by which the rate of the rate of the respondent number 5 had been reduced from rupees 148 from 147
142.94 per quintal.
from 140
Page Lordship, 57 of our.
no, that I know from where to where. That-
Was 148.91 per quintal, quoted by respondent number 5, Lordship. Page
From rupees 148.91 to rupees 148.91 per
quintal.
quintal
As it was the
to 142.94. Full stop. The petitioner's counsel submits that in view of the above reasons, what?
Regarding Lordship vehicle and boat Lordship.
Okay. The petitioner's counsel further submits that the petitioner had not
Clause 14 Lordship, details. um, 22.
submit that the petitioner did not have sufficient number of goods vehicles or good carrying boats as required under clause 14 of the NIT dated of the NIT. That's all. As such, the
All passenger boats and dumper Lordship.
in as much as the respondent number 8 had
Five.
dumpers and
Passenger.
passenger boats. As such, the selection of the respondent number 5 as the successful bidder should be set aside. And a fresh NIT should be issued, is it?
Okay.
Is it? And a fresh NIT should be issued. Next, Mr. J. Roy, the learned counsel for the respondent number 5 submits that the documents on record clearly show that the petitioner had not complied with clause 10, 14, 21, and 24 of the NIT. He further submits that though there is though there is no uh, express words stating that char area experience certificate need not be deposited. Need be submitted, comma. The fact remains that unless the certificate was submitted, there was no way for the respondents to come to a finding as to whether a particular bidder had char area experience.
And it's, clause 3 may be seen, my lord,
Pustaka.
page 22.
He further submits that clause 3 of the NIT, of the terms and conditions of the NIT, required that the bidder should be financially sound and should have a thorough knowledge about the transportation route covering all GPSS and FP shops, riverine area, char area, etc. of Dhubri district, as above 84% of the beneficiaries lived in rural areas. Anything else?
That clause 21 says that priority, like lordship may see the second sentence, my lord. Priority should be given to state bidder and having adequate knowledge in the char areas for smooth functioning and transportation of rice and so on.
He's not a state bidder.
He is not a state bidder. Rather, he is a-
Priority preference, lordship. It's not
Okay, next.
mandatory, lordship.
Mr. J. Roy further, he can make any, he did not disturb you. Let him make, he can say anything. Huh? He can say that the best tennis player in the world is from some state in South India or North India or what. How does it matter? He can say anything. We might not accept. What do I say? Yes, regarding what, Mr. Roy?
My lord, the clause 21, my lord, says that priority should be given to the state bidder.
Submits that clause 21 further provides that priority should be given to the state bidder having adequate knowledge of the char area. So he submits that the petitioner, that is point number 5, is a state bidder having adequate knowledge of the char areas, while the petitioner is not a state bidder and does not have any knowledge of the char area. Correct. That's all.
And clause 10, my lord, that the tender fee and the earnest money, my lord, be deposit.
Yes, sir. No, that is enough, right? Let he also say something. Mr. S.R. Barwa, the learned counsel for the respondents number 1 to 4, submits that the earnest money of rupees 25 lakhs, which was to be deposited in the shape of a fixed deposit in favor of the district commissioner Dhubri, was not done by the petitioner. The fixed deposit had been made in the name of the petitioner himself, which was in violation of clause 10 of the NIT. First off, further, the petitioner had paid the tender document fees of rupees 5,000 in online mode and not in the shape of a demand draft payable in favor of the district commissioner Dhubri. First off, the petitioner also did not have any char area experience certificate. And he also did not submit. And it also did not submit the original solvency certificate.
So he has no right to
Good
question
stuff.
about the negotiation.
Full stop. As the petitioner's technical bit was declared non-responsive, the petitioner cannot make a challenge to the subsequent negotiation made between the state government and the respondent number 5, which was made in the interest of which was made in public interest. That's all. What about this nationalized bank? I'm not, because his solvency certificate was issued by ICICI, not by a nationalized bank. Huh? Nationalized private sector bank.
So it is a private sector bank.
It's a private sector bank. What do you mean? What do you mean nationalized private sector bank? There is a private sector bank and there is a nationalized bank. There is nothing called a nationalized private sector bank. If it's nationalized, it's nationalized. That's all.
That's why, my lord, I placed that segment, my lord, Central Coalfields Limited. Para 43, that's why I placed that judgment. Para 43, my lord.
Yes, 43, yes.
If an lordship may say, middle portion of the paragraph, my lord. On the more important significant of the subject is the three Tata Cellular, which gave importance to the lawfulness of a decision and not of soundness. Lordship got it?
Yes.
If an administrative decision such as a deviation in terms of NIT is not arbitrary, irrational or unreasonable malafide or bias, the courts will not judicially review the decision taken. Similarly, the courts will not countenance the interference with the decision at the behest of an unsuccessful bidder in respect of a technical or procedural violation. This was quite clear that clearly stated that by this court in following Tata Cellular in Jagdish Mandal State versus Odisha in the following words. Judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether choice of decision is.
No, you see, there is one issue, my lord. Is it a essential condition of contract? The solvency certificate issued by because there are various judgments.
Yes.
Padar scale
Yes.
or Padar seal.
That is the main
If
case.
it says that if it's a essential condition of contract, then
Ultimately,
you cannot deviate from it unless you make a deviation for everyone.
but the lordship may say clause 24, the last sentence, my lord.
Yes.
The bidder should not be a bank defaulter. So,
The 24.
yes, last
The bidder should not be the bank default.
bank
So
defaulter. So, madam, that is the purpose of the solvency
bank.
certificate, that he should not be a defaulter. Unless because he is given a 10 crore certificate, my lord, that stability certificate. So he is not a defaulter. Unless he is a defaulter or something is there, then of course that can be questioned, my lord.
anyway, right. Anything else? I have heard the learned counsel for the parties. Clause 3, 10, 14, 21 and 24 of the terms and conditions of the NIP states as follows, page 22 and 22 and 23. So, sir. The next para, the technical bid of the petitioner had been rejected on the following 4 grounds by the Technical Bid Evaluation Committee. Full stop. Number 1, tender fee was paid in online mode, but not by way of a demand draft. in favor of the District Commissioner Dubri. Number two, earnest money in the form of a fixed deposit was not made in favor of the District Commissioner Dubri, but in the name of the petitioner itself. Number three, the petitioner did not submit the original bank solvency certificate. Number four, the petitioner did not submit any char areas experience certificate. Next part. A perusal of the clause 10 of the terms and conditions of the NIT clearly provide that does not speak of the tender document fees of rupees 5,000 was required to be submitted by online mode. It only speaks of deposit of the tender document fees in the shape of a demand draft payable in favor of the District Commissioner Dubri. The above makes it clear that the petitioner has not acted in consonance with the requirement of clause 10 of the terms and conditions of the NIT. The second part of clause 10 of the NIT provides that the earnest money of rupees 25 lakhs should be in the shape of a fixed deposit in favor of the District Commissioner Dubri. A perusal of the fixed deposit this is unreadable. Have you got a better copy? Wait, this is the one. Okay. Fixed deposit number 8063 030 006 5897 shows that the same has been made in the name of the petitioner. On the top of the page containing the fixed deposit of rupees 25 lakh, the following has been written by pen. Inverted commas, pledge to District Commissioner, Dubri, bracket aside. The above, in the view of this court, is not the way a fixed deposit is pledged in favor of a particular authority or person. The fixed deposit, if made in favor of some person or authority, comma, the same is reflected in the fixed deposit itself. And not in the manner it has been shown in this writ petition. Full stop. Though the petitioner has tried to convince this court that the certificate dated 19/10/2024 issued by the Chief Manager Morialok Branch proves that the fixed deposit of 25 lakhs had been made in the name of the District Commissioner Dubri, comma. This court finds that the last date of submission of the tender was
13, 13, my lord, 9, I think, 1 week, my lord. Put a second. 28.
13
No, no.
2020.
Huh?
39.
When?
13 Lordship,
13.
13/9/2024.
Yes. Page
And
27.
and the technical bid evaluation committee
16.
held its meeting on
9.
16/9/2024.
And moreover,
stop.
my lord, he, after filing of the writ petition, he has annexed this not before the tender comes.
Full stop. There is nothing to show that the next para. The certificate dated 19/10/2024 issued by the Chief Manager Morialok Branch, Bank of Baroda. Actually, it says the contents of is reproduced here below as follows. Page 59. Okay. Actually, I'll take the number also. Number will be letter number BOB/DBPA TN/DEP/2024-25/109 dated 19/10/2024. Issued by the Chief Manager. Next part.
Physical copy of the documents Lordship also submitted to the authorities, page 29 Lordship. Original copy of EFD. The form of fixed deposit. It was submitted on 13/9 itself. Lordship. On 20. It is duly received by the authorities also.
Where was the last date of submission?
39.
13/9.
13/9.
Full stop. Next para.
Here's the seal and signature of the bank authority. It is page 28.
Anyway, right, next. Anyway, what about that, your document fees of 5,000, you have not paid it as per demand draft.
Lordship,
Online mode is not required.
but without paying the online Lordship, but he cannot complete the process Lordship, submission of bill. Maybe they also submitted this way, but separately they have submitted the demand draft. Because this is the format Lordship without.
What have I said
online
next?
bill.
Full stop. Next part. The letter dated 19/10/2024 does not state that the fixed deposit was made in favor of the district commissioner Dubri. It only states that it was pledged in the name of the district commissioner Dubri. The terms and condition number 10 require the fixed deposit to be deposited in favor of the district commissioner Dubri. The pledging of the no the play the handwritten note made in the fixed deposit stating that the fixed deposit has been pledged to the district commissioner Dubri has not been signed by any person or authority.
But the bank seal signature is there.
No, no, madam, these are all things. This is everything computer. Who writes in the pen? It's like giving your class 10 certificate. School education will give you a class 10 certificate, and on top they'll write this certificate is for Ms. R. Devi. No one does that. It's all in computerized. When you go tomorrow, you go and make a fixed deposit in your name. I'm quite sure they will not write in handwriting on top. This certificate is for Ms. R. Devi. They will be written in the fixed deposit itself. Your name will be computerized there.
Column regarding.
Then because your name is there in the column where the DC's name should have been there. Your name is there. That's why there's no column. It's very clear, Mrs. Madam. Very clear. You have put your name where the DC's name should have been there. Next paragraph. The fixed deposit made by the petitioner carries the name of the petitioner. And the said fact makes it clear that the column reserved for the person to whom the fixed deposit was to be made in favor of has been filled up in the name of the petitioner itself. In light of the above, this court is of the view that the petitioner has not complied with clause 10 of the terms and conditions of the NIP. Next paragraph. With respect to whether it was necessary for the bidders to submit char area certificate. This court finds that though it has not been stated in black and white in the terms and conditions that char areas experience certificate should be submitted by the bidders, the authorities would not be able to know whether a bidder had char area experience, unless char area certificate were submitted by the bidder. Full stop. There is also nothing stated to the effect that the petitioner had submitted had made any, no, that's all. That's all. Unless you submit, how will they know whether you have char area experience?
Lordship, this is not mandatory.
I agree, it's not mandatory.
Mandatory, Lordship,
Okay.
and also, this experience certificate was not sought for in this, column of the.
Okay, okay, right. The, now, clause 3 of the terms and conditions of the NIT required that a bidder should have thorough knowledge about the transportation route covering all the GPSS and FP shops, riverine area, char area, etc. of Dhubri district, as above 84% of the beneficiaries lived in rural area. Clause 21 provided that priority should be given to a state bidder having adequate knowledge in char area. The requirement of having a knowledge of char areas having been spelled out in two clauses out of the 29 clauses of the NIT, it is quite apparent that a bidder was required to have an adequate knowledge of char area. To enable the respondent authorities to come to a finding that a bidder had adequate knowledge of char areas, the bidder would have required to submit would have required to sub would have would have would have required to submit statements or certificates to that effect. Yes, sir. Besides the above, the respondents have rejected the petitioner's technical bid on the ground that the petitioner had not submitted the original bank solvency certificate. Yes, sir. Clause 24 required that a copy of the solvency certificate was required to be submitted, and it does not state that the original copy of the solvency certificate was required to be submitted. It only stated that a copy of the solvency certificate was to be submitted. Accordingly, in respect of clause 24 accordingly in this respect, this court is of the view that the rejection of the petitioner's technical bid on the ground that he did not submit an original hard copy of the bank solvency certificate is not sustainable, keeping in view clause 24 of the terms and conditions of the NIT. Correct? This is only copy. It does not say original.
But, Lordship, it has to be original.
No, but where does it say original? It says copy. It doesn't say original copy. It says copy. Where do you get, from where do you understand copy to be only original? Supposing I ask you for a copy of your document, does it mean I want a copy of the original? I mean, I want the original. It only means I want a copy of the original.
I think it can be interpreted like.
What to do? We have no time. We have got a lot of series on. If I keep this series, again problem. Buttered. Buttered. I think we'll keep it buttered. Because let me think. It'll take some time.
I think Lordship can, keep it part of.
There is no stay, no?
No.
There is no-
We have entered into agreement also, my lord, page 68.
But
We'll keep,
agreement is only till 31st March.
no, we'll finish it up. We'll finish by next time we finish. What agreement for this?
Contract Lordship, this
We
Contract?
are executing the contract.
period is.
Because
31st.
public service is being involved. And it's short areas, my lordship knows.
Okay, just say. Hearing concluded, judgment reserved. It'll take some time, but.
Well,
Okay.
well.
Yes.
Page 68 is my contract, my lord.
Huh?
Page 68 is my tender agreement, my lord, with the authorities.
Okay, just write one thing. Mr. J. Roy submits that a tender agreement has already been has been executed between the respondent number 5 and the state respondents on
On my lord, on my lord. On 16/10, my lord,
16/10/2024,
24.
Oh.
Annexure 2, page 68.
which is to expire on 31st,
March
March.
2020.
31/3,
31st.
31/3/2025. That's the time.
And Lordship, this judgment covers our case.
Huh?
The judgment regarding consider construction Lordship.
Give me which paragraph? The one you gave me. You have given me already.
Already given.
Then why you want to give me twice?
We are relying on this judgment Lordship.
Okay. Yes.
May it please your lordship. Lordship, the petitioners are president and secretary of lordship, market management committee, lordship. Market management.
Yes. So what do you want?
Lordship, what has happened, lordship? We are running a market, lordship. Agreement is at page 31, lordship.
Yes.
Kindly produce clause number 6 of the agreement, lordship.
Yes.
The agreement shall be terminated immediately upon any order from the district administration,
Yes.
lordship. So without passing an order, lordship, the private respondent is running the market. And we have approached the respondent authority several times, but they have not considered our representation, lordship. At least our representation may be considered and disposed of it accordingly, lordship.
Yes, Mr. Data, why don't you file why is the NIT not being issued?
My lord, well, actually, he requested that his representation may be disposed of.
Okay.
That
Right.
is why I have not gone.
Okay, right. Heard, Mr.
P. Boardley, lordship.
P. Boardloy, learned counsel for the petitioner. Also heard Mr. L. Data, learned counsel for the PNRD department. The petitioner's counsel submits that in terms of the letter of agreement dated 1/9/2023, executed between the petitioner? No,
Market Management Committee Saturday weekly market, Lordship.
between you and the executed between whom?
Between the respondent authorities and the petitioners, Lordship. Office of the block.
Acha, executed between the petitioner and the respondent. Respondent number,
Here, executive officer is represented on behalf of the block development officer, Lordship.
Respondent number 4, man.
respondent number 4. Respondent number 4 is different.
My lord, BDO is the executive officer.
Executive officer.
Acha, respondent number 4. To run the Saturday weekly market under the Bihar Guri Anchalik Panchayat.
Bihaguri Development Block.
Huh?
Bihaguri Development Block,
Acha, under the Bihar Guri Development Block,
Lordship.
comma. The agreement could be terminated only from an order from the district administration. However, without any order being issued by the district administration,
Lordship.
the respondent number 5
Lordship.
has been allowed to run the market. Respondent number 6.
Respondent number 6, private
Respondent number 6 has been allowed to operate
state market.
the Saturday weekly market. He submits that the petitioners have accordingly submitted an application dated. What is the date? The problem is your thing is in English, but it is the dates are in
2024, Lordship.
Huh?
9/1/2024.
9/1/24.
9/9/2024.
9/9/2024 to the respondent number
3, Lordship.
3 to take a decision on the petitioner's representation to allow the petitioner to run the said weekly market. However, no decision has been taken by the respondent number 3 till date. He accordingly submits that the present petition can be disposed of if the respondent number 3 is directed to take a decision on the petitioner's representation
Lordship.
within a specified time period. Mr. S. Datta, learned counsel for the PNRD department, submits that he has got no objection if, to the prayer made by the petitioner's counsel. Ms. Paras. In view of the consent of both the parties, the respondent number 3 is directed to take a decision on the petitioner's application dated 9/9/2024 within a period of
2 weeks.
within a period of 2 weeks from the date of receipt of a copy of this order. The writ petition is according to this program.
Obliged.
Me, please, your lordship. My lord, may kindly pass over the matter for a day as Mr. G.N. Sahiwala, senior counsel, have to leave the court due to medical emergency.
Okay, right. On the prayer made for adjournment made on behalf of Mr. G.N. Sahiwala, which is not objected to by Mr.
N. Barwa.
N. Barwa, list the matter
The first week of January, your lordship.
in January, in the first week of January.
A date.
Twenty-one is thing is right. No one appears for the parties on call. To start. The matter pertains to the settlement of the Tau Suapata Part 3 Tata Kali Ghat. For the period from 1/7/18 to 30/06/19. As such, it appears that the writ petition has become infructuous. Full stop. However, as no one appears for the petitioner, the writ petition is dismissed for non-prosecution. You are appearing here, Mr. Chetia? No. You want to be your name? Mr. M. Chetia appears for the deputy commission. Huh? Is it actually 19 term expired, but he's not here, so. Yes, item?
Item 23.
Yes.
So in this matter, my lord, the incumbent against whom, my lord, the contempt is filed, he has retired, my lord. Perhaps we have to implead the new incumbent.
Correct. Then
And I pray for time, lord, for.
Mr. H. Gupta prays for time to complete the new incumbent. Mr. M. Buya appears for the
Yes,
anyone?
Lordship. New incumbent, so I cannot.
The old one
Hold on.
appears for respondent for the respondent.
Respondent.
List the matter after
Ma'am.
after 3 weeks.
What's it like?
No one appears for the party on for the matter pertains to non-compliance with the order dated 18/5/2018 passed in WPC 6124 of 2016. In the interest of justice, list the matter after 3 weeks.
My lord, as per.
Fresh steps.
No, my lord, service complete, lordship. As per Lawajima order dated 11/11/2024.
11/11. Okay.
My lord,
So what is to be done here?
service complete, my lord, matter will become up for admission. And
So
affidavit,
you tell me what is the case about?
yes, regarding lordship, my lord. Stone Casa lordship. By violating, my lord.
Look,
Stone Casa by violating, my lord, norms, my lord.
is this a PIL? This should be a PIL, I think. This is a PIL. This is, you want some people to, you want these stone crushers to go out of an area because of the health effects of the stone crusher on the surrounding area. Huh?
Accident due to.
What accident? Who has accident?
Or due to truck and dumper lordship.
Correct.
Like-
So which person, Mr. ABC? Who has the problem? No one. You are fighting a basically PIL. You go to the division court. Division bench.
Our representation may be. considered. There is
Bench.
Lordship, Lordship. File at page number 78, Lordship. This is before the deputy commissioner. Type copy is just 76, Lordship. Type copy, Lordship. By the local people, Lordship. Then, Lordship, 84 is the before the pollution control board. 84.
Okay, I think,
Then it can be done, Lordship.
okay,
Then
right.
94 also, Lordship.
Heard, Mr.
Three Gogoi.
T.
D.
D. Gogoi. Learned counsel for the petitioners who submits them. The petitioners are agriculturists
Yes, sir.
who are residing. No, who are agricultural living on farmland. However, two stone crusher units have been set up near the land, which has caused various health hazard problems to the persons living in the vicinity of the stone crushers. Full stop. He also submits that due to the operation of the stone crushers, the trucks and dumpers that are being operated are destroying the rural road connection that is being used by the uh, by the by the petitioners and their families. Full stop. He accordingly submits that though the petitioners have made representations to the authorities to shift their existing stone crushers from the nearby lands, as the same is in violation of the executive order number 6 given under the Assam Land and Revenue Regulations, 1886, no decision has been taken by the district commissioner. Which district commissioner? Kamrup district, till date. The petitioner's counsel submits that the present writ petition can be disposed of if a direction is issued to the district commissioner. Kamrup district, Amingaon, to take a decision on the petitioner's representation status complaint dated 11/12/2018.
Yes, sir.
Within a specified time period. Next
And also,
paragraph.
my lord, before the pollution control board. That also.
You cannot do one. Cannot be one, you cannot have two. Next para. Mr. R.R. Goy, Learned Counsel for the Forest Department, and Mr. Oh, should we ask instead of DC, you want the Forest Department to do it?
Because my forest.
Look, you see, stone crusher is Forest Department.
The forest department and.
So whatever I said,
Commission granted by this.
he accordingly. Is issued to the DFO or principal chief? To the DFO. To respondent number?
Respond number it will be 6.
To the respondent number 6. If the petitioner's representation dated 19/12/2018. That is actually,
They have written to DC, they have not approached the
no, they have written to the PCCF also.
Yes.
Page 92.
92 lordship.
So let the representative considered by the DC. The
DC as well as for forest because pollution control board is also.
If the respondent number 6 takes a decision on the petitioner's representation. Full stop. Next para. Mr. R.R. Gogoi, Learned Counsel for the Forest Department, and Mr. M. Chetia, Learned Counsel for the District Commissioner, submit that as the petitioner's representations are of the year 2018, the petitioner may be allowed to. The petitioner may submit a fresh representation to the respondent number 6 with regard to their grievance. Full stop. If the same is submitted, a decision can be taken on the same by the respondent number 6. Full stop. The petitioner's counsel submits that he will submit a fresh representation to the respondent number 6 with regard to the grievance of the petitioners. Full stop. Next, in view of the consent of the parties, the petitioners are given the liberty to submit a fresh representation to the respondent number 6 with regard to the grievance. Full stop. The respondent number 6 shall thereafter take a decision on receipt of the petitioner's representation at the earliest and preferably within a period of 5 months from the date of receipt of the petitioner's representation. Full stop. In the event that the respondent number 6 should also take a decision only after giving an opportunity of hearing to the owners of the stone crushers that may be that may be affected by the decision to be taken by. Writ petitions accordingly disposed of.
Obliged.
In this case, in view of order of this honorable court, passed earlier, grievance of the petitioner has been.
It has become infructuous.
Is
Mr.
A. Paul.
A. Paul, learned counsel for the petitioner, submits that in view of the interim order passed by this court on 18/9/2019, granting they're directing the APDCL to provide a temporary electrical connection to the petitioner. The writ petition has become infructuous. Mr.
W. Ahmed,
W. Ahmed, appearing for,
response number 1 to
appears for the respondent number 1.
1 to 5.
1 to
5.
5. Full stop. In view of the submission made by the petitions counsel, the writ petition is closed as infructuous.
May please your lordship, as per order 29/2024, lordship, they are proposing to pay the ordinary dues amount loss.
Lordship, his serial number is 165 and 166. Sanction orders are issued by the.
That
Step by
submission
step.
was made by on 29/2024.
What to do, Mr. Counsel? Money doesn't grow on trees.
They have been disbursing money, lordship. Already I have submitted.
Yeah, they have been disbursing. Your number has not arrived. You're still in the queue.
Lordship, my work order was in the year of 2016, lordship, but they have disbursed in the work of 2017, lordship.
Death record.
Huh, Dev?
2017, lordship.
What?
Work order.
What?
After my work order, lordship. My
Also,
work
they have given someone earlier who has.
order- Yes, lordship.
Okay. But what to do? You see, what happens is earlier one person's number was around 7 or 8. Then the next court date, his number became 100 and something. Then I asked her why.
No,
She-
I'm not. going to
he-
say that. Lordship,
Because earlier what they were saying was that as per the seniority of work orders, they were giving the bills. Now they have changed it, seniority of claims and whatnot. I don't know. They are, what to do?
no, my claim was also first class.
So what to do? Should I chase them with a big danda? What am I to do? What do you want me to do? Am I going to be wearing a policeman and run behind them? Hey, why are you not giving him? There are around 4,000 of you who have to be given.
Now we are on a.
You just have to wait your turn. What to do?
They have to maintain the punctuality at least, lordship.
Huh?
For punctuality, lordship. At least they have. No, we have punctuality also. lordship.
What?
Tamser Ali, he is saying.
Oh,
That-
Tamsher
that-
Ali.
yes, lordship. That was not followed by them, lordship. That is the problem, lordship. One junior receiving the money.
This term will.
Now what to do? If now the lawyer is here. Now we have scolded the lawyer enough. What to do? Very difficult.
Let his time come, Lordship. We are honestly trying to give the contractors, Lordship.
The problem is that
They have not maintained chronologically. That is the problem, lordship.
Now, chronological list has been prepared.
the problem is the government was least bothered about payment. They did not have the money. They asked you to do the work. Or they had the money, used it somewhere else. I don't know. So they have taken you for a ride, but what to do? You want the money or we should send them to jail? What do you want? You choose. If we send them to jail, money is gone.
Money lordship. Admittedly.
Now then you have to wait. We also feel for you. That's why we are taking up your cases, which actually should go to civil court. And you'll come to this court after how many years? When did you finish your contract work?
2016,
16. When did you come to the court?
2020.
20. Yeah. If you go literally by the book, limitation, just wait. Now at least something is there. At least you've got a chance. Only thing is they'll be delayed, but at least you'll get. Right.
We have faced it, that is the problem.
Huh?
We have faced a problem, Lordship.
Mr. Counsel, you see, there are not only you, there are a number of lawyers who come to this court saying the same thing. Now, what can we do? We have got to now, we cannot say that you should get preference over someone else. Supposing I say, no, okay, you are 165, he should get preference over number 60. Then number 60 will come to me and say, "Arey, what is this? I am seniority.
That is why, Lordship, if they follow the seniority list, follow is not problem. Seniority doesn't error. That's the
Right.
problem.
List the matter after 4 weeks. Yes.
Yeah, Lordship, I am not praying for 4 weeks, but Lordship will pick up this matter after vacation, Lordship, so that I will get some concrete instruction. Today morning, I talked to the authority. They said some process is going on. They said some sanctioning process is going on.
Look, out here you have admitted the amount.
Yes, that is
Huh?
admitted, even.
You have admitted the amount.
Yeah.
Then you've got to sanction and pay, that's all.
That process is going on, what they have said, Lordship. So on the basis of oral instruction, Lordship, I am not taking any.
So you have not, you have, so he's not in the list till now.
In the list, Lord.
He's in the list.
In the list, the subsequent process is sanctioning.
What is his number?
Number that is not with me, but they have said that he is already in the list. He has 4 number of schemes he worked, 2 in the contempt case, Lordship. All 4 has been sanctioned. And so far as these 2 is concerned, sanctioning process is going on. But that is his oral telephonic instruction, Lordship. So I am waiting for the written
Right.
instruction.
A perusal of para 6 of the affidavit filed by the respondent shows that the petitioner is entitled to an amount of rupees 24,35,000 for the improvement of road from Sujit Mushahari's house to Padma Bill Road at Naigaon, Batabari, and rupees 20,000 against improvement of road from Temna House to Garja Sali Road at Naigaon, Batabari. This is at para 6, page 35, bottom part.
That is his own house.
Huh?
That is the house of the petitioner himself.
Anyway, this is what
He's a
you.
local contractor.
Okay, Mr. P. Nayak submits that he needs further time to obtain instructions as to whether sanction for the amount has been given and funds have been allocated. Accordingly, he lists this matter after 4 weeks. He will do it. What is to be done?
The inquiry had to be done, my lord. The inquiry is complete. If Lordship posted the day after tomorrow, I will furnish the report, my lord. Even I
Okay.
have the report, my lord, but all the petitioners have not signed because 2 or 3 after the 1, 3 are in the Baska district. They have to return back and sign the report, my lord.
So you'll give it when? Day after tomorrow?
Day after tomorrow.
Okay. Mr. L. Bora submits that he will give the copy of the completed verification report by Wednesday. This is the matter of Wednesday. No one appears for the petitioner on call. No one appears for the writ petitioner on call. List the matter after the vacation.
This is the review petition.
I think we'll allow the review. No point.
On 14 notice was issued to 1 month has already.
Right. I think the second time we should notice to them, right? No one right, Mr. S.C. Kayal, Learned Counsel appears for the review petition. No one appears for the respondents / writ petitioners. Even though notices have been issued twice. Pusta. As per the office note, comma, service report has not been received from the respondents, from the respondent number 1. However, in view of the fact that 30 days have lapsed from the date of submission or from the date of issuance of the notice, comma, notice is deemed to be served upon the respondent number 1 in terms of the proviso to
Section 27, general clauses.
not proviso,
Provided section.
in section 27
The general clauses.
of the General Clause Act. Full stop. Next paragraph. Right. The review petitioners council submits that the impugned order dated 21/11/22 passed in WPC 7117 of 2022 should be reviewed in view of the fact that the judgment of the Supreme Court in the case of Union of India and others versus Ashish Agarwal reported in AIR 2022 SC 2781 had been wrongly applied while disposing of the case. First up. Next paragraph. The review petitions council submits that the decision of the Supreme Court in Ashish Agarwal Supra was not applicable, is not applicable to the instant case, as the notice issued to the respondent under section 148.
Yes, sir.
148 of the Income Tax Act 1962.
61.
1961 had been issued on 31/3/2021, that is within the time limit, and also the assessment had been completed on 14/3/2022. Correct?
Lots.
2022 or 21?
22.
22. Good start. he submits that the decision of the Supreme Court would only be applicable in respect of proceedings relating to past assessment years, provided that the notice issued under section 148 of the Income Tax Act had been issued on or after 1st April 2021. Full stop. In the present case, this court has. No, next. I have heard the cause for the petitioner. For the review petition. On perusing the impugned order dated 21/11/2022, this court finds that the writ petition had been disposed of in terms of the judgment of the Supreme Court in Ashish Agarwal Supra and instruction numbers 01/2022 dated 11/05/2022 issued by, where is that?
Case 23 issued by DIC OSD
Page 23.
23. Last case.
Issued by the Ministry of Finance, Department of Revenue, Central Board of Direct Taxes, ITJ section. However, in the case, in the the case before this court, the notice had been issued under section 148 of the Income Tax Act on 31/3/2021. And the same is not in consonance with the decision of the Supreme Court in Ashish Agarwal, wherein it has been held that the benefit of the new provisions of the Income Tax Act would be made available even in respect of proceedings relating to past assessment years, provided the section 148 notice has been issued on or after 1st April 2021. The same also has been reiterated in another Supreme Court judgment passed in the Union of India and others versus Rajiv Bansal. Have you got that?
Yes.
2024 0 Supreme bracket SC 854. Full stop. In view of the above reasons, this court is of the view that the review petitioner has made out a case for review of the impugned order dated 21/11/22 passed in WPC 7118/2022. The impugned order dated 21/11/22 passed in WPC 7118/22 is accordingly recalled. The review petition is accordingly recalled. WPC. WPC. What is that? What's WPC?
7118 item 30.
7 double.
118.
Okay. is restored to file. List WPCs also after the vacation. So in all the others, also same order, except that there'll be a
Read petition number.
lead petition number will be different.
Much.
They're not appearing because they know their decisions.
Much.
Lead petition. Item 37. What to do? We are for whom? One,
For reference number 1, Lordship.
2 and 3, no AD. Oh, you are appearing, very good.
I have already. 50% have already been paid.
Correct.
Rest 50%.
They have to take the sanction, what?
For remaining 50% already, financial sanction has been issued, Lordship, and it is pending before the finance department for issuance of FOC, Lordship.
FOC.
Lordship.
FOC means what? Huh?
Ceiling.
Ceiling proposal.
Lordship.
No,
It's
so
a
ceiling
lordship.
proposal has to be sent to you or it has,
Finance budget. So we are,
yeah, PWD?
I am referring to PWD.
Oh,
Finance is not a party.
Finance not a party.
final party. Okay, so it's still pending with the finance.
Lordship.
So when is it likely to be sanctioned?
After, within 4 weeks, Lordship, they have to-
Okay. So wait,
Yes.
Mr. S. Data,
Lordship.
Learned Counsel for the respondent number 1 submits that the remaining 50% of the amount payable to the petitioner is awaiting sanction of the finance department.
Lordship.
Which finance department, full stop. Accordingly, please this matter after 4 weeks.
Look, in this case, my lord, the order consists of 2 parts. One part is already complied with, my lord. One part that means, my lord, security release of security deposit of rupees 2,02,000 have already been released recently. The second part is, my lord, for release of the feast money already deposited. So that part is not complied with.
Who is to be,
Should be the forest department, my lord.
forest?
Meaning, my lord, already notice has already been issued, my lord. Lordship may kindly see office note dated 10/12/2024.
Affidavit of service has been filed?
Affidavit of trustee has already been annexed to the said affidavit.
Yes, you'll be appearing or what? Huh? Sure, he has given an affidavit. Saying that 2 and 3 have received, but one is
20,
refusing.
Yes, one is not, my lord, not available, my lord. In the office at the relevant point of time.
So, if 2 and 3 are not coming, then we issue warrant of arrest or what? Available. What to do otherwise? What choice do we have? If you all are not appearing.
I'll take
I want that missing autonomous boxes that fishery matter. Today.
Okay, I'll take instruction in this, for number 2 and 3 along.
Okay, right. Mr. R.R. Gogoi submits that he will obtain instructions from the respondent number 2 and 3.
And my name will reflect in the cause list.
Registry to reflect the name of name of Mr. R.R. Gogoi in the cause list
SC Forest.
as SC Forest. Full stop. Office note indicates that, no, the affidavit of trustee service submitted by the petitioner indicates that the respondent number 1 has refused to accept notice. Now what to
2
do?
and 3 already received.
Let me,
Okay, let us see next,
My lord, date may be fixed
After
before
Bihu.
Bihu. Before Bihu.
after view.
After Bihu. All right, Lord.
39.
I will on behalf of resolution six. We have
Six.
filed our affidavit today. We'll file a reply later be after application.
Okay, right.
Respondent number six. Respondent six. I'm told.
Here, Mr.
K. M. Gupta.
A. Gupta appears for respondent number 6. The submits affidavit has been filed. Mr. Pawar submits that. Mr. B. D. Howard submits that. He'll be filing affidavit in reply within
After vacation.
within 4 weeks. Leave the matter after
Seventh
the-
of February,
Bihu vacation.
after on seventh of February.
Oh, you said, okay.
Seventh
Leave the matter after 3 weeks, 7th February. 7th were fixed a lot. Oh, February?
February.
Oh,
January is all holiday this time. We are lucky.
40.
Interim order will continue. Interim order will continue.
interim order to continue to the receipt.
Please, my lords. My lords, we have served the copy to the respondent, to the respondent number 2.
We have served him the copy, Lord.
Huh?
We have served the copy to the LOI.
Number 3.
Three.
Number 3. You have served.
Yes.
There is some. Nothing. Okay, right. Mr. A. Barwa appears for the petitioner. Mr. S. S. Roy appears for respondent number 1 and 2 and submits that notice has been served upon the respondent number 3 by the respondent number 1 and 2. What to do then?
Come up for admission here.
No affidavit.
Lordship, we are filing. We will file
Mr. S. S. Roy submits that he'll be filing affidavit within
3 weeks, Lord.
3 weeks. Leave the matter out 3 weeks.
Please, your lordship. This is regarding.
MAC.
Yes,
Give me.
yes.
Give me the orders passed.
WPC 3065.
Huh?
WPC 3065.
Yes, my
Give me a copy.
main order.
So in light of this only,
Yeah.
okay, heard Mr.
SK Mohan.
Huh?
SK Mohan.
H.K. Mahanta learned counsel for the petitioner. While Mr. D. Gogoi appears for the
Missing autonomous council at
for the missing autonomous counsel.
yes, lordship, 4 and 5 lordship. Respondent number.
4-5. Mr. M. Chetty appears for
6, 7 and 9, ma'am.
6, 7 and 9. Full stop. Then you take this last order, para 8 and 9.
Yes, madam.
Para 8 and 9 you take. Then, so, yes, so we dispose of in this line.
Yes,
The counsels for the respondents submit that in view of the disposal of a similar matter in WPC 3065/2024, that is Dibrugarh Fishery Cooperative Society Limited versus the state of Assam and 5 others. Wide judgment and order dated 20/08/2024. The present writ petition can also be disposed of in the same light. Full stop. Next para. Para, which paras should we apply?
3940.
Huh?
3940. 47. Lordship, Lordship has already passed a similar order, my lord, at page number 72.
Page
In the
72.
light of this judgment.
I have page 72.
Yes. Page number 72, Lordship.
Acha, it's here. Then you take from here, it is here, page 74, para 5, 6. Till the end, to 76, 74 to 79, with five from 5 onward. Okay,
And the matter orders as dated, my lord. That should be cost, my lord.
huh?
Dated, 3 orders were passed, my lord.
Okay,
Allotment. Annexer 11A, 11B and 11C.
let us see a prayer for subjects. In view of the above, the orders dated, page, there's a orders dated in the prayer portion will be there. Orders dated,
29.
order number 29/6/2024. Order,
All of these in dates.
huh?
All the 3 orders.
All the three, all the, with the, it's a order numbers, page 34. All the 3 orders, all same date. Okay, are hereby set aside. Okay, you can take back this. No, you don't need, it's there, it's there. It's page 74 onward. 52.
My lord, this is a review application. Letter was regarding, my lord, non-payment of some higher charges, my lord, of vehicle. At the time of COVID, my lord, some vehicles are hired by the district authorities. And the health department was supposed to make the payment. Now, while disposing of, we only want that, my lord, that verification part to be, my lord, given to us.
Huh?
Verification of the bills, my lord, before payment. Only on that part we are prepared to review. Page 16, lordship will see. The order starts at page 14.
Yes,
Our part is mentioned at para 5. S. Sarmasi appeared, my lord, on behalf of the health department. He submitted that, my lord, since it has been already verified. We want to be verified because some letters we have got from the district authority, they said that you have to.
you want to
Verify.
re-verify,
Only to verification.
re-verify, better re-verify.
Ultimately before making.
Because otherwise they are going to, because she has said that verify, you are both the same department.
No, my lord, it was by the district authority, by deputy commissioner's office, my lord, it was hired. At the time of COVID situation.
No, but Miss S. Sharma appears for whom?
No, she is for health department.
Then?
Well, but the admissible report was given by the, my lord, deputy commissioner in the, my lord, para 4.
Okay,
Only thing, my lord,
we'll have to
notice
issue notice, that
yes.
means.
And one more thing, the finance is a party here in, my lord. It should be a pro forma respondent, my lord. We have nothing against the finance. Otherwise, I cannot appear. my lord. It was, finance was a party in the writ petition also.
Finance department.
You're a finance department. Finance department is a party here.
Yes, sir.
Was in the main writ petition.
Okay, right,
It
Mr.
may
B.
be taken
Gogoi,
up with the pro
Mr.
forma
B. Gogoi, learned counsel for the review petitioner. Petitioners
Yes, petitioner.
submits that the impugned order dated
16/9. 16/9/24.
That's
Page
okay, let me,
Take some water. Lots.
big problem.
Yes, my lord, from 10:30, my lord.
Huh?
From 10:30, my lord, continuously, my lord,
Ah,
declaring orders and all.
not getting, it's not getting, I mean, it's slightly improving a little bit, but not.
And
too
also
fast.
you'll have to take warm water.
Have to relax, not give orders, just keep quiet,
Lots of.
that's all. What about Mr. D. Gogoi? Order dated 16/9/24 passed in WPC 7381/2023. Should be reviewed in as much as though the bills of the petitioner have apparently been verified by the district, but
By the respondent number, my lord,
by the respondent number 1, 2, 3.
no, lordship, by 2 and 4 in the review petition.
No, who wants to re-verify now?
Yes, my lord, by the review applicant.
Who-
One,
who-
1, 2
And
and 3.
the review applicant was the respondent in WPC, what number?
My lord, 1, 2 and 3, yes. 1, 2 and 3.
But she's the one who has said that.
No, it is a 4. 4 and my lord, say 5.
4 and 6, my lord. Sorry, 4 and 6.
No, who wants to re-verify the bill? Four and
It is
six.
by my lord respondent 1, 2 and 3. The health
But
department.
you come to page 16, Miss S. Sharma, alert counsel for the response number 1,
No,
2,
that's why I said, my lord, this is my lord, apparently my lord, she should not have said so, my lord. In fact, the instruction. also
whatever I
got
said.
it, my lord.
comma. Numbers 1, 2, and 3, as submitted by Miss S. Sharma.
No, lord. she
In
will
the
see there are
impugned
4.
order, comma, the same is not correct. Full stop. He accordingly submits that the that even if he submits that the respondent number 1, 2, and 3 should be allowed to
Yeah.
have a verification slash re-verification of the petitioner's bills. Full stop. Issue notice returnable in 4 weeks. Ms.
RM Barwa.
R.M. Barwa accept notice on behalf of the finance department,
Lord, she will mention it as a performer respondent, my lord, from my.
comma, who is the performer
Yes.
respondent. Full stop.
Same nothing to do.
Review petitioner to take steps for service of notice upon the
One,
respondent number.
my lord, 2 and 3, 2 and 4 will come.
Acha, Mr. M. Chetty appears for respondent number 2 and 4.
2 and 4. will.
2 and 4, then petitioner takes steps for service of notice upon the respondent numbers, the respondent number
1.
1
Yes, sir.
by the insert post with any within 3 days. List the matter on given date.
Yes.
Actually, we make it 3 weeks and let it be before.
Yes.
Yes, 9 January.
Obliged.
Finish.